Marc, you should have filled out a notice of appearance.
So good afternoon, everyone. Welcome to the Appellate Division First Department. Before we get started with the calling of the calendar, it is the tradition of the court to acknowledge the first sitting of an Associate Justice. And today, we acknowledge the first sitting of Marcia Michael, Justice Marcia Michael. So just... Justice Marcia Michael is a graduate of Albany Law School of Union University. Prior to her ascension to the bench, Justice Michael was an associate at a civil litigation firm in Bronx County, and she served as a court attorney to a number of distinguished jurists, including the Honorable Deborah Dowling, the Honorable Janice L. Bowman, and most notably, myself. Justice Michael began her judicial career in 2015 when she was elected to the bench as a New York City civil court judge in Bronx County. She was assigned to New York City Criminal Court, where she presided over domestic violence, misdemeanor matters, as well as conducted jury trials. Who is that? Gave him up immediately, right? Okay, that's a no-no, please. Where was I? She was elected to the New York State Supreme Court in the 12th Judicial District, Bronx County, in 2018. She served as an Associate Justice on the appellate term of the Supreme Court for the 1st and 12th Judicial Districts from February 2022 until her appointment to the Appellate Division First Department. Justice Michael administers a judicial internship and mentorship program. She is also the chair of the Gender Fairness Committee of the Unified Court System, 12th Judicial District, a member of the Judicial Friends, National Association of Women Judges, the Judicial Council of the National Bar Association, and is a board member of the Supreme Court Justices Association of the City of New York. Justice Michael's appointment to the First Department will not only add to our diverse and esteemed bench, but is also a welcome for all of us. So again, please join me in welcoming Justice Marcia. Thank you. So Justice Michael, you have 1 minute. I'm going to turn the clock on. And when the red light goes on, stop. Say something.
Thank you for your warm welcome. I'm super excited to be here. Let's get started with work.
Excellent. And I want all the attorneys, please note, she ended before the red light went on. So that's a hint, okay? So I'm now going to call the calendar. You know the spiel? I'll let everyone leave. Nothing personal. So we have approximately 7.5 hours of argument time requested. Obviously, that is not going to happen. Sundown is 4:30. However, we do not want to be here with sun up, okay, sunrise. So ask for the time that you actually need. Keep in mind, we are fully aware of your arguments. The red light is for you. It is not for us. If we have any additional questions, we will proceed with those questions past the red light. People v. Jameek Beard.
Good afternoon. For appellate, 4-1.
Good afternoon, Your Honor. The people request
414. Havon versus Port Authority of New York.
Good afternoon, Your Honors. Paul Hoffman and Schweitzer for the plaintiff, Ellen Havon. Request 10 minutes. Good afternoon, Your Honor. For defendant appellants 5 and 3.
For the respondent, Your Honor, 5 minutes.
62535. C. Joseph versus Marcy C. Excuse me.
Good afternoon, Your Honor. For the appellant, 5 minutes. Good afternoon, Your Honor. For the respondent, 5 minutes.
5-5. Sera versus Embassy Hotel.
Appellant request 5 and 2, Your Honor.
Sean Harrison, defendant, 5 minutes.
525. Carrie versus Bay.
Appellant, 5 minutes, Your Honor.
There's no respondent. Did you still wish to 5 minutes, or did you wish to submit? 2. Maldonado versus Young and Booby Realty.
Appellate request 5 and 2, Your Honor.
Again?
Again.
525. People versus Marcy Gray.
Appellant request 5 and 2, please.
525. Crown Wisteria versus Chabani.
Appellant request 5-2.
525. Bova versus Paramount Leasehold.
Did the appellant respondent, court contracting 5 minutes to rebut this?
How much did you rebuttal? I'm sorry.
2.
Plaintiff respondents appellants requesting 7-3. Respondents Paramount. I didn't show my 4 minutes, Your Honor.
52634. People versus Jamal McPherson. 414. Wojcik? I know I messed that up. Law firm versus Mall. Wojcik, thank you.
For the respondent appellant 5-2.
You have a cross appeal? Yes. 5352. HSBC Bank versus Gford. Again, there's no, you're the respondent? There's no appellant, so did you still wish to argue? Okay. 2. Ortiz versus New York City Department of Motor Vehicles.
Good afternoon, Your Honor. For the petitioner, 10-2. Please. For the respondent, 10, Your Honor.
Certainly. 525. Supply Company versus Hardy Way. Can't see. Oh, excellent. Thank you so much. Matter submitted. People versus David Williams.
Good afternoon, Your Honor. Appellant request
515. Mernavov versus Memorial Hospital.
Give to the respondents 5 minutes.
525. Lindaman versus VNO 100 West.
Good afternoon, Your Honor. Plaintiff appellant requests 5 and 2, please.
Respondent request 5.
525. People v. Benjamin Rucker. Matter submitted. Tadco Construction versus General Contractors. Matter submitted. Castellati versus Free. Matter submitted. First case for argument, People v. Jameek Beard. You may proceed.
Good afternoon, Your Honors, and welcome, Your Honor. May it please the Court, the Legal Aid Society by Ivan Pantoja for Mr. Jameek Beard. We respectfully request that this Court modify Mr. Beard's level from a level 3 to a level 2 for 2 primary reasons. First, because the Sera Court failed to appropriately consider the mitigating factors that Mr. Beard presented. And second, because a level 2 is the more appropriate classification.
But he's a presumptive level 3, is that correct?
There was an override that was applicable because of a prior conviction, but as Your Honors know, although an override is automatic, it is certainly not mandatory.
What was that prior conviction for?
It was an attempted rape 1.
Ah,
For that case, he was adjudicated a level 2.
so this incident occurred in 2018?
Yes,
And was he on parole at the time of this incident?
he was.
And he was on parole for what?
For that incident, Your Honor.
Ah.
This incident unfortunately occurred about 7 months after his release.
So 7 months after he's released from incarceration, he's on parole and he engages in similar behavior, in that it's a sex offense.
It is a sex offense, although completely different behavior.
It wasn't a rape, I understand that. It wasn't a rape, right?
Absolutely, not to minimize his actions.
So why then, what would the mitigation be, the mitigating factors be, which would allow a downward departure from the presumptive level 3 to a 2?
Well, first, I would say that typically an offender who has a prior classification, like in this case, who has a level 2, and then commits a subsequent crime, typically in those situations, that offender has completed sex offender treatment the first time.
By the way, how many sex offenses does the defendant have, or did the defendant have?
Well, the basis of this crime was because of the multiplicity of his prior misdemeanor forcible touching.
So was there one in 2007, one in 2008, 2014, and then this one 2017?
Yes, so this was what would be considered a misdemeanor act, but because of his prior misdemeanor forcible touchings, it resulted in the persistent sex abuse conviction because he had more than
It's a little bit more than touching. He ejaculated on the female on the subway, right?
completely repugnant.
A little bit different than a touching. I mean, I
Absolutely, Judge.
recognize there is that touching, but normally when we talk about forcible touching, we talk about hands or other parts of the body. We don't talk about ejaculation.
Absolutely gross. Judge, all I would say though is.
I'm sorry, I interrupted you. What are the mitigating factors?
Well, one, like I said, he didn't finish sex offender treatment the first time because they didn't accommodate his learning disability. One of the mitigating factors here is not only did he complete sex offender treatment, he also completed vocational treatment.
Didn't the Sera court already assess that and consider all of that?
Well, our position is they didn't appropriately consider it. So,
What more should they have done? What greater consideration would there be?
well, I would say, Judge, his actions, although repugnant, really, he should be a level 2. One, the REI risk total determined by the judge put him squarely in a level 1. The total points here were 65.
But there was a presumptive override based on his previous felony conviction, right?
Yes.
So let's not talk about that. Let's move on to the mitigation.
Right. So the mitigating factors were the ones that were presented that we feel weren't appropriately considered.
And how were they not appropriately considered?
Well, second, primarily because his sex offender treatment, the reason sex offender treatment is mandated is because it works. This is the first time that he completed sex offender treatment because the first time they weren't able to appropriately accommodate his learning disability. That's a significant mitigating factor that he completed sex offender treatment.
Well, it's not that he completed it, but that he did so in an exceptional way. All you're highlighting is that he engaged in treatment.
Yes, and that he completed it.
Well, kudos to the completion, but you have time on rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors, and may it please the Court. Jennifer Mitchell for the People. The Sera Court properly adjudicated defendant a risk level 3 sexually violent offender and correctly denied his request for a downward departure. All of defendant's purported mitigating factors were thoroughly considered by the Sera judge below, and in any case, any alleged mitigating factors were outweighed by the seriousness of this underlying offense and defendant's criminal history. Defendant had 2 prior sex crime convictions and committed this underlying offense while he was currently on parole for an attempted first-degree rape conviction. And just 7 months after his release from prison, he rubbed his groin against a female stranger while riding the subway and ejaculated onto her pants. When caught, defendant admitted that he thought he could get away with it. For these reasons, the Sera Court properly denied defendant's downward departure request, and if there are no questions, then we ask that you affirm. Thank you.
Thank you.
One thing I'd like to mention is also his disciplinary record. He only had 1 Tier 2 infraction. Now, certainly risk factor 13 deals with someone's conduct while confined. But I think why this is appropriate in the downward departure context is someone who has satisfactory conduct while confined will get no points. But someone who has near perfect conduct will get the same points. That's why this is often sometimes addressed in the downward departure context, because that risk factor itself doesn't differentiate between someone who does satisfactorily or someone who does near perfectly. That was another mitigating factor that was presented.
Also considered by the Sera Court.
Yes, but not sufficiently is our position. Lastly, the reason we believe a level 2 would be more appropriate, and this was mentioned not only at the hearing but in our papers, is that there's a very little difference between a level 2 and a level 3 in terms of verification, notification, and what information is publicly available for individuals. But what it does do is it bars him from living or being 1,000 feet from a school or where children reside, even though none of his offenses have dealt with those who are underage. That certainly could be an impediment to rehabilitation. And if your honors have no questions, I thank you for your time.
Thank you. Harrison versus, excuse me, Havison versus Port Authority of New York.
May I proceed, Your Honors?
Please.
And may it please the court. Paul Hoffman for Mr. Havison in this appeal. There are two aspects that the court below did not properly grasp with. The first was the level of control and substantial control over the equipment and selection. And
So
use.
what was the level of control based upon the contract and also based upon the testimony by CH2M Hill?
Well, we can start with the contract itself, Judge. It says that the CH2M was to provide all management and engineering services. They were to participate in all planning, and the testimony was they participated in 3 meetings a week. And during those meetings, the testimony from Mr. Chin and Mr. Splendoria shows that during those meetings, there was a full discussion of not only the equipment, but the location and the work that was to be done.
And was there any specific testimony about whether he attended, whether anyone from CH2M attended the meetings at which they were discussing what equipment the plaintiff was going to use?
Yes, Your Honor. The testimony was that
And
CH2M...
where is that testimony?
Mr. Chin testified and Mr. Splendoria testified that CH2M ran the meetings. They were the entity that ran the meetings for the Port Authority. The Port Authority appeared, but CH2M itself was there. There are citations in my brief.
I understand there were references to that was the general practice. Are there any references? I couldn't find any references in the record that showed that CH2M attended meetings specifically about the work to be done by Mr. Havison.
Yeah, well, then it would just have to be custom and practice. That would be the inference, Judge,
I see.
of course. And that's
Isn't
what
there a
our
reference
position was.
in the record to CHM not actually really dictating what sort of equipment would be used? Isn't there deposition testimony to that effect?
There's a deposition testimony that we cite that says that that CH2M would participate in the decision-making of the equipment that would be used, and if in fact equipment had to be rejected, they would be involved in helping select other equipment and other locations where the work would be performed. I think the most important aspect of the contract itself is the one section that says that CH2M was to ensure good workmanship is performed. And I point that out in that it's not that they were to inspect and look at what had been performed, but they were to ensure that good workmanship was performed at the time that the work was being done.
And I was intrigued by your reliance on that. Is there any basis for concluding that good workmanship specifically refers to safety equipment, safety conditions?
I think that just the general concept of good workmanship means you do it in a safe manner, and it certainly couldn't mean you do it in an unsafe manner. And this is the requirement that the Port Authority put upon CH2M. They require in that agreement that all OSHA regulations and New York and New Jersey laws be complied with. And in this case...
Did your client testify, state whether CH2M was present and whether they were present during conversations or discussions as to the safety equipment to be used?
Yeah, he testified that he thought they were there that day, but he was not 100% sure. But I do point to, Your Honor, that the contract requires that CH2M have an inspector at all locations where the work was to be performed. So if that inspector wasn't there, then they violated their obligation under the contract with the Port Authority to have somebody there and to oversee the safety that was being done with that equipment that had been inappropriately supplied onto the work site that day. Now, Mr. Havison.
Counsel, if I may.
Yes,
Here,
Your
Justice
Honor.
Kennedy. If I may, where in the record does it indicate that, CH2M had control over the means and method of the work? Where in the record is that?
I think that they certainly weren't the only entity that had control. We certainly
That wasn't
know
my
that-
question. My question is, where in the record does it indicate that CH2M had control over the means and method of the work performed?
I think that it's inherent in the 31-page single-space contract with all of the provisions saying that they were responsible for all engineering and management of the project.
If I may, I'd like to follow up with another question.
Yes.
Regarding the deposition testimony, because there's a lot of deposition testimony, is there anywhere in the deposition testimony that bears this out, that they had control over the means and method of the work performed?
I think that in answer to that, it comes from the testimony about what occurred in the 3 weekly meetings prior to the work being performed, where CH2M ran the meeting and was participating in the selection of equipment and location where the work would be performed.
Thank you. Your time on me, brother.
Thank you.
Good afternoon, Your Honor. Christian Gannon for defendants and appellants. Your Honor, just to answer your question specifically.
Thank you.
There is a companion case, Sera, which is an accident that happened at the same location, the same job site, the same contract. In fact, all the same counsel were involved in that case. In the Sera case, Robert Chin, who's with Didone Electric, when he was asked, and this is in the record at...
Well, that's not in the record in this case.
It is, Your Honor. It was part of the summary judgment motion, and this deposition transcript is part of the record.
Okay.
Where is it in the record?
Starting at 1092, Mr. Chin says that he took his marching orders from CH2M, that's a quote. At 1105, he said, in record 1105, he said, CH2M would tell a journeyman electrician that they were improperly performing work, including the means and methods of the work. So Mr. Chin answers that question, that they were directly involved in the work of the individuals involved in this contract. Mr. Splendoria, in this case, he was the Aldridge Vice President and Senior Project Manager. He testifies at record 616 that CH2M was involved with recommendations as to what equipment should be used for the joint venture's work. He also testifies that at 617 of the record, CH2M gave authority to do the work or not to do it, and this involved many factors, and Splendoria said, quote, it starts with hours of work, track rights, placement of equipment on the tracks. You kind of go down the list and make all the decisions. So CH2M, when you also look at the contract, they had tremendous amount of responsibility on this job. They're not just paper pushers. They're not just keeping record management. They have a $20 million contract. They were required, among other things, to have inspectors on the job full-time at any place where work was being done. Now, the other issues with regard to my clients are the indemnification provision. I think that clearly under the contract, CH2M owes indemnification. All we're asking the court to do is just to reinstate the indemnification and contribution claims.
That rises and falls with our finding on the motion for summary judgment, correct?
I'm sorry, Your Honor?
And that would rise or fall on our finding on the summary judgment motion, correct?
Yes, I think two things, Your Honor. I think, first of all, I think they owe us indemnification. I don't think negligence is a trigger for that, which is what the lower court found. Even if negligence is a trigger, I think there's enough testimony by the plaintiff, by Mr. Chin, by Mr. Splendoria in this case that there's a question of fact as to what the roles were for all these parties, who's negligent, who owes indemnification to whom. So I think in that regard, Your Honor, we ask that the lower court decision be overturned and you reinstate the indemnification and contribution claim.
I have another question about the contract. In the brief, you mentioned that there's a mention of CH2M's duty to inform path of any unsafe conditions. I think that's at 1343. Does that constitute a duty to create a safe workplace, or is it only a duty to inform if there's an unsafe condition?
Well, Your Honor, I think it's both. I think it's part of it is in their role in setting out the work that's going to be done on a project. It is to create a safe working environment, but also under the contract, they had an obligation to identify unsafe conditions and make recommendations for their correction. So I think that's clearly in the contract. And even just the section alone on page 690 of the record, it talks about they were to provide the technical support functions for each of the following systems for the project, which included vehicle onboard equipment, track and trackside mounted equipment, wayside equipment. That's the equipment that's involved in this lawsuit, the use of that. Their inspection services.
I have another question. Is there anything in the record that shows that they had specific knowledge of the equipment that was going to be used by plaintiff in this case? That is the Genie lift instead of the Cho or Chu? I don't know how it's pronounced.
Instead of the
Sorry?
Instead of the Chu, right, Your Honor. Your Honor, it's not clear in the record that CH2M was actually at the location when CH2M was actually at the location when Mr. Havison is alleged to have said, this is the wrong piece of equipment for us to use. However, they breached their contract by not having an inspector there when this work was going on, where they would have learned of this issue of using the wrong piece of equipment. They could have made recommendations or even stopped the job. So I think there can be many causes of an incident, but I think they breached their agreement with the Port Authority. I think they clearly did not fulfill all their obligations under their agreement, and they're negligent. But that's something for the jury to determine. These are all questions of fact that are better decided by the jury at a trial of the case.
Thank you.
Good afternoon, Your Honor. Stephen Willig of Donovan Hayden for the respondent, CH2M. Clearly, Your Honors have read the record and know what's in there, and I want to highlight a few items that were discussed by appellants to particularly refer you to the record and what exactly the contract says, among other things. Looking at the record on page 691, which is the 31-page CH2M contract, which is very detailed and which sets forth what they were supposed to do and what they were not supposed to do. But it says under task 1 at the bottom of the page that a consultant, that is CH2M, representative, I'm sorry, let me start this again. Inspectors shall report to and receive instructions and daily assignments directly from PATH. They were not supposed to be everywhere or at all times. They were supposed to be where PATH told them to be. They had to have.
Wasn't it part of their duty to pass on to PATH the request for various equipment to be used, and then to confer with PATH about what equipment would be used, participate in that decision, and then pass that back to the people who are going to be doing the physical work, right?
Absolutely, but it was in terms of, can we get this equipment to the location at this particular time?
Right,
That's
but that would
exactly
also
what they're
mean that
doing.
if they didn't have a safe piece of equipment to do that work, would they say use an unsafe piece of equipment, or would they say don't do the work?
It's not up to CH2M to decide that. That's means and methods for the contractors.
But it also states that the inspection services shall ensure that only first, and in paren, new material is used, good workmanship is performed, and work is in accordance with all approved plans and contract documents.
Absolutely. They come in when the work is completed to make sure it's done according to the specifications, according to the contract documents, and it's done well, and it's standing and viable. They're not there observing each aspect of the work, every step of the work, watching workers put hammers into nails. That's not part of what they're doing.
But the contract also requires them, as I understood it, to advise PATH of any unsafe conditions. So if PATH said this piece of equipment isn't available, only this one is, if CH2M knew that would create an unsafe condition, wouldn't it be its obligation to do something about that?
If that's what they understood, if they observed something that was unsafe, they were supposed to advise PATH about that. But they are not the contractor. They're not the one who's determining the means and methods of this particular work. If the contractor wanted to use a lift instead of a chew, that's up to the contractor to determine.
But it says they should also report any discrepancies to PATH.
I'm sorry?
It also states that they are to report any discrepancies to PATH. So that would seem to suggest that if they did see that there was something that was not correct, that they were supposed to report that to PATH.
If there was something not in accordance with the contract documents, et cetera. And the record, I think, is clear without question that they were not present at this site at that time. The
So
testimony.
is that, so your adversaries state that the fact that they were not present and they should have been present is a violation of the contract?
From the section I just read from the contract, Your Honor, I'd say no, because they're only supposed to be present where PATH tells them to go that particular day. PATH doesn't tell them to go to every particular site at every moment the work is being done. They weren't directed to be there that day. PATH never complained that they were not there that day. They were supposed to be somewhere else, and that's exactly where they were.
So there's also testimony in the record that your client facilitated safety meetings. Do you dispute that?
I'm sorry?
There's also testimony in the record that CH2M facilitated safety meetings. Do you dispute that?
That's what they facilitated meetings. They got people together, they set an agenda, and people discussed what was going on the job site.
So you agree that they facilitated safety meetings?
Yeah, put meetings together, absolutely. That's what they did. They put lots of meetings together. They looked at lots of work, and that's what their role was. But their role was not in terms of determining means and methods of the work. And I think
would you also agree that they had the authority to stop unsafe work that they observed?
They were supposed to report that if they observed. They did not have authority to stop that work. And I think we cited in our brief the portions of that. And I want to just refer, because I know that the panel has seen the record, and I want to refer to pages 1091 to 1093 of Mr. Chin's testimony, which I think unequivocally shows that what they were doing, in fact, that's an apt description. Mr. Chin is asked about what CH2M does, and he says, for example, if we want to paint 4 rooms, they go to PATH and say they want to paint 4 rooms, and they may come back and say, no, you can't paint 4, we only have 3 available. That's what the marching orders is referring to. We take their marching orders from them to decide what is the scope of the work that can be done that day and what equipment can be used. Not that they're determining how to do that work.
But that's certainly not the scope of all of the work that your client did for a $50 million contract.
No, but in this particular instance, when they're talking about us directing the work, controlling the work, it's absolutely not the case.
Thank you.
Thank you, Your Honor.
I'm going to try speaking quickly, Your Honors, simply because there's 2 provisions that I think I should cite to you. At the record at page 1340 is a provision that states that CH2M was to provide the required technical support functions for each of the following systems of the project: vehicle onboard equipment, ATC equipment, track and trackside mounted equipment, and wayside equipment. So they were to provide technical support, not just sit there and pass on a message. I also refer, Your Honors, to
Your adversary states that they were to provide technical support. However, they still were working at the direction of PATH.
Yeah, well, the language says required to provide technical support. So what else would PATH want other than to be told this would be appropriate equipment? That's my argument, Your Honors. And I also point out, if I may, at 1341 of the record, the language that talking about these inspections, inspectors, rather contrary to what Mr. Willig said, inspectors shall report to and receive instructions of daily assignments directly from PATH. The number of inspectors assigned shall be sufficient to provide full-time coverage of all of the contractor's active work shifts and locations on each work. That's the language of the contract. There was no, according to Mr. Willig's client, there was no CH2M inspector on the site, and that is their defense, in fact, for why they didn't make sure that this inappropriate machine was not used. Again, we point out that CH2M was part of those 3 weekly meetings prior to them deciding not to bring the CHU onto the site. They said use a man lift. It was approved by them to use a man lift, which is, everybody agrees, was inappropriate.
Thank you.
Thank you.
Your Honor, I'll be very brief. I want to point out two portions of the record. One is page 687, which says that CH2 is to, quote, attend all meetings and conferences as determined by PATH between PATH and the contractors and others.
As determined by PATH?
Yes, I agree with that, but they're still at all the meetings.
Okay.
And the other portion, Mr. Hoffman already cited one that I was going to read to you in terms of the inspections. but at page 692, they are to identify and evaluate problems, recommend solutions, and verify implementation of path-accepted solutions. They're to have inspectors, as Mr. Hoffman said, on every shift, at every location where work is being done. The fact that they weren't there when Mr. Havison is alleged to have said this is the wrong piece of equipment is a breach of the agreement. They did not fulfill their agreement based upon that. And my last citation is, I just had it. They are on page 689 of the record. They are to analyze all corrective actions taken or proposed by the contractor as soon as they are submitted and provide comments as appropriate. And this is the last one, Your Honor, page 693 of the record. Under conditions and precautions, it's quoted to say, the consultant, meaning CH2M, shall immediately inform the authority of any unsafe condition discovered at any time during the course of this work. So if they were there on location, as they should have been under the agreement, they would have been aware of this condition that Mr. Havison brought to everyone's attention. They could have made recommendations to correct it and potentially have avoided this accident from the very beginning.
And is it your position that using the genie lift for this purpose was an inherently unsafe condition?
No, Your Honor. See, that's going to be another issue for the jury because what I think will come out of trial is that they had to use the man lift because they could not physically get the chew into location at that site. So I'm not going to concede that this is a violation of anything using a man lift. It was just the piece of equipment that they had to use based upon the configurations of the.
Do you have a position? There was also discussion about using a come along or another kind of equipment. Do you have a position on that?
Yeah, it's such a confined work area, and a lot of this equipment has to be used on the flatbed of a train. Because they're hanging these cables, which is the ATC system. It's the automatic, basically a track communication system. So they made their best decision based upon what they could accomplish in that moment, but CH2M wasn't there at all to even participate in that, and that's a breach of the agreement.
Thank you. Joseph C. versus Marcy M.
Good afternoon, Your Honors. My name is Joseph Maiano. I represent the appellant, Joseph C., who, as we know, as a result of a willfulness hearing held before a support magistrate, was found willful, and a recommendation of incarceration was made, which was confirmed by the family court judge. This court entered a stay pending appeal, and conditioned upon this appeal being perfected by this term, and that was done. I think the briefs are reasonably comprehensive. Mr. Ehrlich's brief, reasonably comprehensive, and I'd be happy to answer any questions that I can.
No, we have no questions. You have rebuttal.
I'm sorry?
No, you don't have any rebuttal. Anything else you want to say?
Oh, that's fine.
Thank you.
Good afternoon. May it please the court, my name is Matthew Ehrlich, Law Office of Matthew H. Ehrlich, for the respondent, Marcy M. There's really just, and I'll try and be very brief on this. There's a few issues here. First of all, the appeal is untimely. Whether or not the appellant received the papers from the court, which became an issue, they were provided to the appellant's counsel no later than June 2nd of 2022, pursuant to the Family Court Act. He had 30 days from there to appeal. He did not. The appeal was not taken until February of 2023. Excuse me, he made an application to the court at that time. Pursuant to the decision from the court on May 30th of 2023, they found that it was untimely and summarily denied appellant's application.
So it was untimely regardless of what errors were made by the family court or not in getting in whatever errors were made in service, because in any event, he had it by May.
Correct. He had it by June 2nd. So at the very least, he had 30 days from there to then appeal it. He didn't do it that time. He waited almost 8 months. It was done in February. That is well after the time that he had So all the other issues are really moot and irrelevant here. Now, there are just, if I'm going to just touch on them briefly, with respect to the findings of fact, the court did issue a findings of fact and a order entering money judgment. Yes, there were no summations written, but he had an opportunity to open and close in the actual hearing. With respect to the actual therapist, the 3101 was not provided to us until 3 months into trial, which is after the time that Ms. Monet had already testified and had completed all of her testimony. There was no other witnesses on her behalf. We received it thereafter. So Ms. Monet did not have an opportunity to even oppose or produce an expert to combat the expert's testimony, what would have been the expert's testimony in this matter. In addition, the alleged expert, the therapist, did not meet the appellant until 2 years after the appellant had already been in contempt of the judgment of divorce back in 2013. So it's impossible for that therapist to have opined about anything that happened between 2013 and 15. Furthermore, during the trial and even in the appellant's brief, he admitted to working for at least 2 years and 10 weeks while allegedly treating with this therapist, and earning over $200,000 during that time. And instead of paying any of the monies owed to my client, he did not. He merely contributed whatever monies he could to his current wife. So there is no, the therapist was properly precluded. With respect to cohabitation, there was specific language in the notice of proposed judgment that required the alimony to end only upon my client's remarriage or the death of either party. Therefore, cohabitation is absolutely irrelevant as well. So we ask that the court affirm the lower court's decision. Thank you very much.
Thank you both. Sera versus Embassy Hotel.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff appellant in this matter. I looked for similar decisions. I couldn't find one. I mean, this is a very unusual decision. What the trial court essentially did, as you know from reading the record and reading the briefs, is the trial court made a factual finding that the plaintiff didn't have CRPS. Now, the problem with that, I think, legally, is that juries are never asked to determine damages. Appellate lawyers, appellate judges, trial lawyers, trial judges, we always look at damages, but we do it for legal reasons.
But there was no mention of it. I mean, except the one doctor who said, yeah, I added it to my report because somebody asked me to do so, but I'm not really sure why they, who asked me or why they asked me.
Well, Judge Weber, Dr. Guy and Dr. Groff both said that the plaintiff had CRPS. And one of the points I tried to make in the brief, and I hope I did make it fairly, cogently, is that if you look at the testimony, the cross-examination of the defendant doctors, the plaintiff's lawyer was able to get the defendant doctors to admit that many of the symptoms, many of the complaints that the plaintiff had were absolutely characteristic of CRPS, which is
how can we give much weight to Groth holding that opinion, given that the only appearance of CRPS in his records is in an undated addendum, which has no context, there's no idea, no sense of where it comes from. How can we give that any weight?
Right. He doesn't even really say that that was based upon any diagnosis. He just said that someone must have approached him and asked him to include a CRPS diagnosis.
So if I can respond, Judge Gessmer and Judge Weber, I think what his testimony was, and the first time we saw him was October 5. The first part of the testimony was that he doesn't make CRPS diagnoses immediately, right? There was no allodynia at the time, which is simply the hypersensitivity on the hand. And he waits until this occurs afterward. So his diagnosis was predicated based upon the plaintiff's symptoms over time.
But it's undated, so how do we know what it is?
His testimony. He has his testimony, and he has Dr. Guy's testimony.
But he couldn't recall when he made the addendum.
I'm sorry?
He could not recall when he made the addendum.
I get it. Listen, it's not ideal testimony. Obviously, you don't want to have addendums to records, but this was his testimony.
And he made the addendum after being approached by some unidentified person.
That was the testimony, and the jury.
Not based on whether, in fact, over time he was able to ascertain that he had CRPS.
Right, but my point is, the jury heard all this, right? The jury heard about the addendum. His testimony was always that he had CRPS, and that's one note. Now, the jury could have, if it chose to, disregard his testimony because they found that he wasn't a truthful witness. They could
So
have
why
found,
can't we find that there was insufficient evidence to support a determination that there was CRPS?
because I'm a prevailing party. As a prevailing party, I'm entitled to have the evidence construed in the light most favorable to me as possible. 5501C absolutely commits to the appellate division and to the trial court the duty to determine whether or not a verdict is excessive, but I don't think it allows a judge or trial judge or an appellate judge to disregard testimony that's not only supported by one doctor, not two doctors, but when you read the cross-examination of plaintiff's attorney with respect to the defendants, he got some very, very good admissions, including the symptomatology was reflective of CRPS, the plaintiff was not a malingerer, the plaintiff was truthful, he was stoic, and you actually have in the evidence records from Dr. Guy and from Dr. Goth explaining why CRPS is actually the real diagnosis, including, I'll get to you in 1 second, Judge, including the 3-degree loss of coldness in the left hand, which is a classic indication of that disease. I'm sorry, I didn't mean to cut you off.
That's okay, you didn't cut me off, I didn't speak. Counsel, so should we disregard the 4 of the plaintiff's doctors and the 4 of the defendant's expert that said no, CRPS? We should just go with Guy and Groth?
Well, it's not a question of who you go with, that's my point. I think that this is something for a jury to do. The cases are legion. If you read Nicastro, read your decision in McDermott. It's not the number of witnesses you have, it's do you have a witness who says something? You can have one witness against 5 witnesses, but the jury has the right to make that determination. And lead case is a case that nobody ever looks at anymore, but I am to know it. It's a matter of Silvestri. If you look at Silvestri, it's 44 New York 2nd, it was a case where the plaintiff prevailed based on one handwriting expert, where everybody else said it was actually a real signature. So I don't disagree that they had more witnesses, but that's not really what the test is, because you don't want to have 15 different witnesses so they can come to the appellate division. Judge Weber, may I finish?
Please.
Okay. So it becomes a witness situation. It's just a question of, is there evidence there? If it's construed in the light most favorable to the plaintiff, should it be disregarded? I don't think it should be.
Counsel, if I may,
Sure.
I certainly agree with you that it's not about the number. It's not about the number, but let's look at Dr. Guy's testimony, right? Because I believe he indicated that at least 6 months following the accident, I mean, there was just no reference at all to this CRPS. And then I believe it was again in May of 2022, right? That he had indicated, yes, this CRPS, that's a permanent condition, but and progressive, but that, when he examined the plaintiff, that time, the condition was the same as the first time. So how do we deal with that?
Well, the easiest way to deal with it is when you look at Groth's testimony, and let me give you the page, because it's a kind of big record. I think it's 369. And you look at the testimony of Dr. Guy, which is what you're looking at. I think it's undisputed that CRPS is not a static condition, right? It's not like you're paralyzed. It's not like you have a fractured ankle that isn't being treated. It waxes and wanes. That was the whole import of what happened. And that's one of the reasons why there was this fight, because the defendant said, look, he's not that badly hurt all the time. And our experts, and I think their experts too, said it's an indefinite diagnosis. There's no static nature to it. It waxes, it wanes. Sometimes you're in pain, sometimes you're not. So I don't think that's inconsistent with the testimony of my experts, and I also don't think it's inconsistent with the testimony of the defense experts. I'll try to get the pages for you in my reply. Thank you.
Thank you.
May it please the court, Sean Harrington, appearing for defendants' respondents. Your Honors, what plaintiff's counsel doesn't discuss is the proper standard of review here, which is abuse of discretion. Defendants respectfully submit that the court should give considerable deference to the Bronx trial judge, Justice Ramirez, who heard all the testimony and presided over trial, who in a well-reasoned and 18-page decision came to the sensible conclusion that the CRPS finding was against the weight of the evidence. As Your Honors, I hope recognize, 4 of plaintiff's treating doctors, Dr. Lee, an orthopedic surgeon, Dr. Mirza, and Dr. Leo, hand surgeons, and Dr. Karkar, a physical rehabilitation specialist, all independent medical treating doctors, found no CRPS. The only 2 witnesses that did find CRPS was plaintiff's retained physician, Dr. Groff, and their professional life care planner, Dr. Guy. After plaintiff was told he could go back to work, plaintiff was referred by his lawyers to Dr. Groff, who initially did not find any CRPS. Did not find it. He agreed with plaintiff's independent medical treating doctors initially.
Isn't it often the case that CRPS doesn't appear and become part of a diagnosis until sometime after some occurrence?
That is correct, Your Honor, but I will say that even if you look at his later examination in August of 2016, which was years after his initial examination, he admitted that plaintiff did not display any physical symptoms of CRPS at that time. No sensitivity to touch, no swelling in the left arm, hand, or wrist, equal grip strength in both arms. And he concluded at that time there was no signs of CRPS, but yet he still found that plaintiff had CRPS because it doesn't mean he doesn't have it. Your Honor, I would just like to continue and say that as the court recognizes, he inserted an undated addendum to his report, which he testified at trial. This was not common for him to do, inserting special addendums. Not at all common. He didn't even consult with orthopedic surgeon Dr. Lee. And also I'm sorry, it was not at all common, and even based on his late diagnosis, there was no objective evidence of CRPS. Also, defendant's medical experts, 4 medical doctors, and 1 vocational rehabilitation specialist also found no CRPS. It really doesn't matter what their cross-examinations were about. Their ultimate conclusions was that there was no CRPS. That's the pertinent issue. I'd just like to wrap up and say that keeping in line with judicial precedent, defendants respectfully submit that the court should give considerable deference to the Bronx trial court's decision, Justice Ramirez, who appropriately found that the jury should have based their findings off plaintiff's actual injuries, which was a minor left wrist fracture that was treated non-surgically with a cast for 6 weeks, and a minor left shoulder injury, and based their awards accordingly. I will submit that the $1.2 million reduced award more than adequately compensates plaintiff for such injuries. Even the cases that Justice Ramirez relied upon, which involved plaintiffs undergoing left wrist fractures and shoulder injuries, involved plaintiffs that underwent surgical intervention for such injuries, unlike plaintiff here. So if you have nothing further, I rest on my briefs. Thank you.
Thank you.
Your Honors, I don't think you can credibly call a left wrist injury with a malunion on a 29-year-old a minor injury. Nobody did. Even the defense doctors didn't do it. Judge Kennedy, I have those pages for you, 135, 191 to 193, 213 to 15, and 447.
Thank you.
No problem. I certainly don't disagree that 5501C is a legislative commandment that reposes in judges the obligation to not allow excessive or inadequate awards to come up. There's no question. That's what you said in Donlan. But the fact of the matter is, I think my adversary is just wrong. You can't just disregard jury findings because a judge makes a finding. As a matter of fact, let me point out to you something that I know you know. Even an appellate court judge is not allowed to reduce a verdict unilaterally. They have to give the non-prevailing party the option to do so because we have a constitutional right to a trial by jury. And I think if you look at the totality of the evidence, I'm not saying that, it's not Perry Mason. The defense isn't going to come out and say, I agree, it's not there. It's not how trials work. But we did get significant concessions. We had 2 doctors who testified to CRPS.
Is there any significance that the workers' comp determination was also that there was no CRPS?
Right now, 0, because as you know, the legislature has now recognized, the trial court didn't allow it in, but the legislature has said that those determinations are so out of whack that they're not collateral estoppel as a matter of law, except with respect to employment based upon the modification.
But on the pure weight of the evidence, was there enough in the record, given the late addendum, given the fact that, there did not appear to be any diagnostic determination as to CRPS?
My answer is yes, there is. And again, I would ask you, before you vote, just to focus on the nature of the disease. It's not like a fracture. It's not like paralysis. It's a disease that actually waxes and wanes, and there is no test for it. It is a diagnosis of exclusion, not inclusion.
Thank you.
That's all.
Thank you both. Carrie v. Bay.
Good afternoon, Your Honors. Jason Levine for the plaintiff appellant. Just very briefly, we submit that the defendants failed to meet their initial burden of establishing in the first instance that the plaintiff did not sustain a serious injury as a result of the accident. Plaintiff alleged essentially 2 injuries here, a lacerated spleen and a left knee injury which required arthroscopic surgery. The defendant's medical proof did not address at all the lacerated spleen injury. They submitted the radiologist report of Dr. Eisenstadt, but she did not review a diagnostic film or a CT scan of the spleen. All she dealt with was a lumbar spine and a cervical spine. They also submitted a report of Dr. Nipper, their examining orthopedist. All he did was defer opinion to the appropriate specialty. Well, there was no appropriate specialty submitted by the defendants in initial support of their motion to address this. So we submit for that reason alone, the defendant's motion should have been denied without even considering the plaintiff's proof. Alternatively, assuming the defendants did meet their burden, we submit that the reports of the plaintiff's treating orthopedist and surgeon, Dr. Allegra, was sufficient to raise an issue of fact. He set forth a range of motion limitations, his findings based upon his treatment over several months, as well as his findings during the surgery. He causally connected the left knee injury and the surgery to the accident.
The defendant's radiologist's report was that it was, I think it was degenerative arthritis, right?
There is a notation in the MRI report of some mild degeneration, but Dr. Allegra did address that. He said, yes, there are some mild degeneration in the ligament, but he explained in pretty factual medical detail that the accident caused a strain of the PCL as well as chronic post-traumatic synovitis, which he directly related to the accident. So he did in fact address this, one notation in the MRI report of mild degeneration. So we would submit, under those circumstances, it was sufficient to raise an issue of fact where, as opposed to certain instances where the doctors don't address any findings in the plaintiff's own medical proof, that wasn't the case here. So we submit that the order should be reversed and the complaint reinstated.
Thank you.
Thank you, Your Honor.
Maldonado versus Young and Ubi Realty.
Good afternoon, Your Honors. Brian Isaac, I represent the plaintiff appellant on this one as well. I think the error in the trial court's decision here, according to us, is that we're not dealing with traditional lease situations when you're dealing with homeless people. I think that's pretty clear from the record. My client doesn't have a lease. They're not paying rent. There's this kind of oblong situation where the managing agent, CRS, contracts with Pilgrim to provide the housing.
But your client still has a claim against the actual landlord, right?
Does.
Regardless of what we do today.
100%. And let me tell you, because I knew somebody was going to ask me that question, let me tell you why that's important. If we lose this case, this is what's going to happen at trial. The landlord is going to say, this isn't a traditional lease situation. Oh. This is a situation where we're dealing with homeless people. We're out of it. We don't have these responsibilities. Primary responsibility is on CRS and the city to do that. And they're going to say, this isn't necessarily ours. So that's the problem. We definitely have the landlord, and we definitely have Pilgrim as well. But I think that there's a problem when dealing with this type of situation because we're not dealing with a traditional landlord and tenant situation.
Yeah, but how do we keep the city and CRF in?
I'm sorry?
How do you keep the city and CRF in?
So as you know from Clark's testimony, right, the way that the system works, you know this better than I'm not really expert in it, but I learned it from here. CRS gives to my clients a caseworker, and the caseworker is responsible not just for trying to get them other housing, but to make sure that the housing that they have is.
So he reported it to his caseworker. I forget her name. So he reports it to, right, he reports it to her, and she acknowledges that that she saw the condition.
Correct. The factual question relates to what was done. Ms. Clark's testimony, as I understand it, is that she came on June 1st. There were workers there on June 3rd. It was repaired, and then it collapsed again on June 7th. Plaintiffs say that never happened. They said there was never a repair. They complained for weeks on end. They complained not just to CRS, but they also complained, fair enough.
Right, and then the problem is that Singer, for whatever reason, I don't understand this, whenever they, according to his testimony, whenever they complete the repairs or whatever, they discard the work order, they discard all emails, so there's no record whatsoever of the work having been done. But what more was the CRF worker to do?
Well, the CRS worker was supposed to not only make sure that it was done, but it's actually in the testimony of Mr. Hannon and in the contract itself. If you look at the contract, well, let me talk about Mr. Hannon's testimony first. It's 689 to 691. And he said that their responsibility was, quote, to respond to reports of repairs that needed to be made. That's on 689. As an operations specialist, he was involved in building operations, and he was, quote, obligated to report our findings and to ensure that follow-up was conducted to ensure that repairs were completed. That's 690. 691. There's a 24-hour response time with ceiling collapses, and follow-up has to be done the next day. That wasn't done on 691. And if you look at the one contract that they have on 791 of the record, it's absolutely true that there were other entities who had maintenance responsibilities, but with respect to the responsibilities of CRS, and I'm quoting, they had a responsibility, quote, to cause the apartments to be kept in a clean and orderly fashion. The verb cause, with respect to the rest of the declaratory sentence, shows some maintenance responsibilities. And Judge Weber, with respect to what you had just asked me before, not only did they say they destroyed the record, but if you look at page 839 of the record, this is Mr. Bowen's affidavit. He said CRF, quote, is not in possession of any records indicating that a unit inspection was performed on July 1, 2014. That's on 839.
There was testimony from the caseworker that she inspected, right? That she was there, she reported the leak. When she came back, it was repaired.
Correct. And our clients deny that. Summary judgment motion, question of fact, evidence construed, the light most favorable to my client, not to the movement. I don't have anything else unless you have any questions for me. I'll sit down and let my adversary talk. Thanks for listening.
Good afternoon. May it please the court. Courtney Chadwell from Chiavetti, Corrigan, D. Edwards, Weinberg, and Nicholson.
Are you sure? You seemed a little unsure about that.
It's long. It's a new firm for me, so it's a long name. On behalf of
write it down beforehand so you know.
Respondents, CRF.
But what about the fact that we have no records? I don't understand how you can. How do you do this? You know, there's no record whatsoever. You discard, you destroy all records of any repairs that are made?
So I don't know. I think maybe destroy is a little bit, I mean.
I think you said discard.
Discard, yes. So first of all, that person, Sol Singer, who was the property manager, he's not employed by CRF or the city. He was the property manager. He's the guy, or rather the people below him, who are actually responsible for actually performing the repairs. So he is the one that testified that once CRF, in this case McCabe Clark, who was the caseworker, said, hey, there's this repair that needs done, he jots a note down, he makes sure that the repair is done, and once it's done, he throws it out.
But given CRF's obligation to respond to repairs, wouldn't it have been sensible for CRF to do something about the fact that the property manager wasn't maintaining any records?
Assuming that they knew at that time that he was not maintaining any records, which I don't know that there's any evidence that they did. I do agree with you that it would be better if we had a ton of records to prove this, but I don't think that it's dispositive in this case.
You don't even have a half a ton. You have nothing.
I don't think that's true, Your Honor, because in plaintiff's own opposition exhibits, there is a record that shows that on, and this is page 837 of the record, there is an email sent from Mr. Hannon, and it includes a printout of a report that shows all of the different units for which inspections were done on July 1st. So remember this accident where the ceiling collapses happens on the 7th. Ms. Clark says that, and the record shows that this would have occurred on somewhere on June 30th. She sees that there's a leak. She goes and she tells the super there's a leak. And then they do repairs, and she does follow up, and she confirms that they've done that repair.
Right, and so the plaintiff is disputing that and stating that that never occurred. So what do you have to refute their statement?
So on 837 in this email, there is a printout of all of the inspections that were done on July 1st for which repairs were found to be necessary. And for the appellant's apartment, Unit 41, it says 7/1/2014 repairs made. So it's not just a he said, she said sort of situation. There is a document that backs up the fact that my worker says, or the CRF worker says, I'm telling you, and she's adamant. She testifies not once, not twice, but at least 3 times. I went in there, I told the super, and then I confirmed that there were repairs done. She describes what the repairs that were done looked like. So it's not just her testimony. There is at least one record that says, yes, on or about 7/1, repairs were in fact done to the relevant apartment unit. I think at the end of the day, a lot of what happened in plaintiff's opposition, we made a prima facie case because the pleadings clearly alleged, the theory of liability was ownership and control of the building where the accident occurred, which makes sense because that's where a duty to plaintiff arises. And so instead of addressing that, they conceded it and tried to assert a bunch of things that were not properly pleaded. But regardless of whether you go on what the pleadings say or what they wish that the pleadings said, the lower court's decision remains well-reasoned, supported by both the law and the facts, and it should be affirmed because at the end of the day, even assuming everything that the appellant is saying is right, say Ms. Clark didn't actually report it to the super, and there were no repairs. It's discretionary conduct, and the case law is absolutely clear that no liability can attach for discretionary conduct. The only time liability attaches, possibly, is for ministerial conduct, and that's when the special relationship comes into play. But since it's discretionary, the analysis ends. And either way, respondents prevail. And so we would ask that the lower court be affirmed, and unless anybody else has any questions for me, I'm ready to rest on the brief.
Thank you. So what about the 7/1 notation?
Simple. I'll read it to you. 837, July 9, says work furniture orders, and then it says Bonnie, Dean, Maldonado, 7/1/214, say 837, repairs made. We don't know what the work order is. We don't know what a furniture order is. We don't have an invoice. And here's what we do have, 839 of the record. This is Mr. Bowens. He's the head, and this is what he says. CRF Cluster Model Program, LLC, is not in possession of any records indicating that a unit inspection was performed on July 1, 2014. Take 839, 837, they say the opposite things. I'm opposing a summary judgment motion. And I don't disagree that governmental function immunity is absolute. 100% it is. There's no question. The Court of Appeals said so in Applewhite and its progeny. But this is a situation where if you read 837, when you have a ceiling collapse, you're supposed to repair it in 24 hours. My client said it wasn't repaired for 2 weeks. There's no governmental function immunity when the discretion that you're exercising violates your own standards. Take a look at Haddock. It's directly on point. So I think the trial court simply got this one wrong. And if you look at the very evidence my adversary cited, it conflicts. Their evidence. I shouldn't lose on summary judgment. Thanks.
Thank you. Thank you both. People v. Marcy Gray.
Good afternoon. Robert Hunter, Center for Appellate Litigation for Mr. Gray. May I please the court? trial court was informed that Mr. Gray had potentially filed a grievance against his attorney that could have created a conflict of interest, but it stopped its investigation without
Well, he
even
wasn't
locating.
sure. Mr. Gray wasn't sure. He said he wasn't sure who he filed it with, where he filed it. He wasn't completely certain that he filed it. And then the counsel stated that he or she had not received any complaint.
And that's exactly why the court should have figured out whether or not that grievance had been filed. And it also did not inquire into the substance of what it contained. The best way to do that would have been to
I
wait
thought it
around.
was the fact that the attorney, unless I'm mixing up the cases, that the attorney allegedly did not file a timely 3030 motion.
That was one of the things he mentioned in his initial colloquy, and there's also allegations of not showing up to meetings, not answering the phone, as well as a bail reduction motion. All of these things.
Doesn't
if
the
they're
record contain bail reduction applications as well as a 3030 motion that was actually filed, and the court explained that to Mr. Gray?
Pro se motions by him.
So the court explained that the court did not have the full record of that in front of her. She had just gotten the case today. She explained that now was not the time to make a new application, but it would have been very easy in the time between he made the request and the next day when jury selection started for the court to go back, confirm that these applications were made, confirm if it believed that they were without merit that they didn't
Didn't the court
make.
give them an opportunity to make a record on the next day and no record was made regarding these issues?
I'm sorry, could you repeat that?
The court gave the parties an opportunity to make a record about just that the next day and no record was made. They moved forward with jury selection.
It's the court's responsibility to inquire into a issue that there's a potential for a conflict of interest. Is not incumbent on Mr. Gray to go back and look at the court records himself. He had already raised this issue, and what the court said to him, other than confirming the actual grievance committee number, was, I am doing the trial tomorrow morning. All the things that you mentioned, referring to the 30-30 motion, among other things, if they're in the record, you may have an issue on appeal. But what I'm going to be doing is conducting the trial. And this court in People v. Rodriguez makes the point that when a complaint is shut down in this matter, it's not incumbent on the defendant.
I'm sorry, what complaint was shut down?
An inquiry into the substance of any of these issues. All the court did was try to figure out if there was a number they could get for the grievance committee, and then when they can't find the number, they go forth with the trial.
But as my colleagues stated, the following day, I thought the court gave the defendant an opportunity to address an additional opportunity to address these issues.
And the exchange on the record is just them saying we can't find the number for the grievance committee. At that point, there is no reason for Mr. Gray to think that any of the other issues that he had raised were going to be investigated.
So he just assumed. You're stating that he assumed, and so we should also make the assumption that he assumed that because of these statements by the court, he should not have continued to raise any objections?
It's not so there's a three-step involving inquiry when a defendant raises a potential ground for substitution. The first is that the court has to let the defendant make the request. That happened. We can see that she let him finish. Then, if there's a potential serious ground for substitution, the burden's on the court to figure out what that is. It's not the burden on the defendant to continue to raise those objections after they've been shut down. And the reason I say they were shut down is because after Mr. Gray set forth 3 or 4 reasons that, if corroborated adequately, could provide a basis for substitution, then all the court asked about was, did the grievance committee actually receive this? That's the only thing she acknowledged. With regard to everything else, she says, I'm doing the trial tomorrow morning.
So the fact that she said, I'm doing the trial tomorrow morning, does that not mean that she has considered the other claims by the defendant concerning the bail reduction, the 30-30, motion, the fact that I think that the defense attorney doesn't call her right, doesn't that mean that she has already considered those issues?
There is no finding of lack of good cause that was made on the record, and every case that the government notes in their opposition brief says that there is no good cause for substitution met.
So the defendant stated that he no longer wanted the defense attorney to represent him because the defense attorney was ineffective for failing to ask for a bail reduction, and we know that there had been applications for a bail reduction which had been denied, and to make a 30-30 motion. And so I thought that the court addressed those issues.
The court does not ask him anything about whether or not those might have merit, which is what's required under People v. Sides. And if I could just point out People v. Rodriguez, which is 4683rd 396, it discusses this idea of even when the court asks the defendant, do you have any questions, after saying, I'm not going to look into these issues further, that's not a meaningful opportunity for the defendant to restate their complaints or the reasons for withdrawal.
So I'm looking at I'm looking at Rodriguez here. That's not what occurred. I mean, in this particular case, it was not the court did not shut the defendant down. And in fact, it stated the following day, the court said, is there anything anyone wants to put on the record? And no one says anything. But I'm sorry, you have time on rebuttal.
Sure, thank you.
Your Honors, and may it please the court, Anna Notchik for the people. Prior to trial, defendant was given ample opportunities to express his grievances about his attorney, and still none of those complaints rose to the level of good cause warranting substitution. Defendant's uninterrupted complaints of counsel lasted 3 pages of transcript. Then, after he finished, Justice Neubauer engaged with defendant. She asked defense counsel whether he had anything to add. She asked defendant whether he had actually filed the grievance. She explained to defendant that there was no more 30-30 at that point because the case had already been sent out to trial, and she explained to defendant that many of his complaints were actually about the Department of Corrections and not about his attorney.
Well, did she address the issue? So he had 3 main issues. He had two, the 30-30 issue as well as the bail reduction.
So we would argue that she did address the 30-30 issue because she said there's no more 30-30 at this point, meaning that the court case had been sent out to trial. All motions had already been decided. That inquiry was sufficient to address defendant's complaints about his counsel, none of which rose to the level of good cause warranting substitution. I can address the weight and excessive sentence.
What about the bail reduction? Did she address the bail reduction?
She did not, on the record, address the bail reduction, but we do know from the minutes that defense counsel actually had made multiple bail applications on defendant's behalf. The rest of defendant's complaints were vague, conclusory, like his attorney had not been calling him or visiting him in prison. None of those warranted substitution on the eve of trial.
Should there have been greater inquiry by the court in terms of the substitution of attorney? I mean, she seemed to focus on whether or not there, in fact, had been a grievance against the attorney, or whether a grievance against the attorney had been filed.
And she understandably addressed that specifically because defense counsel had said that he had not received one and that if one had been filed, there might be a conflict of interest. We know from the case law that a grievance does not automatically create a conflict of interest, but she did then address that issue with the defendant. He couldn't remember where he filed it. He didn't have a copy of it. His attorney had never received a copy of it. That's why she focused on that issue, but she did also address the other issues, the 30-30 issue, the fact that many of defendant's complaints were about the Department of Corrections and not necessarily about his attorney.
Did you briefly want to address the excessive sentence claim?
Yes, Your Honor. Given the serious nature of defendant's offense, defendant rode up to the victim on his bicycle. He pointed a gun at the victim's head before turning it and pointing it at the victim's leg and pulling the trigger. He then tried to flee and committed perjury on the stand. Given the serious nature of that offense, the attempts to flee, the perjury at trial, his sentence was well-deserved and should not be reduced in the interest of justice. If there are no further questions, we ask that you affirm.
Thank you.
So I just want to address why it is important that the court did not get into the substance of the potential grounds of the 3030 motion or the bail reduction motion. If he actually did file a grievance that would put his attorney in a position of defending himself, that would require the attorney to potentially disclose attorney-client communications and create.
Now, that would cause the attorney to have to be relieved, and then that would cause the trial to be delayed, right?
Correct, and
we're on the eve of trial now. So the eve of trial, the defendant states, "Oh, by the way, I think I filed a grievance against this attorney. I'm not sure where I filed it. I don't know where I sent it, whether I sent it to 61 Broadway. I don't know what 61 Broadway is. I don't know whether I sent it to the Bar Association, but I think I might have filed a grievance against my attorney." Right, which would have caused, therefore, a delay, and the case would not have proceeded to trial at that time.
That's correct, but it would not have been very difficult for them to suss out, is this just a delay tactic? The number one thing they should have done is actually gotten that number for the grievance committee. The second thing is, if—
Does the record reflect whether a grievance was ever filed?
It does not. We don't know. And we also, to the point about did the court review the substance of these motions, there's no indication that they did. And I understand the government's point that because their kind of review of the record that was not before the trial judge suggests that maybe these weren't the strongest motions. That's not the burden for the side's inquiry, and I'll rest on the briefs if there are no further questions.
Okay, thank you. Crown Wisteria versus Chabani.
Good afternoon, Your Honors. May it please the Court. Andrew Goldenberg for Appellant Crown Wisteria, Inc. So the Court's prior decision holding Chabani liable for breaching the license agreement, that's the law of the case. Justices Gesmer and Weber were on that panel and issued that decision. In that decision, the Court held, quote, Chabani chose to use a cheaper brick that does not—
We're familiar with that decision. The issue now really before us is what damages you should get, if any, in excess of the nominal damages
Correct,
assessed
Your
by
Honor.
the trial court. So, and you suggest two different ways of calculating.
Well,
could you explain the theory behind?
Sure.
I guess one ends up with your client getting something over $600,000, and the other is something over $200,000.
Right. So the
Could
theory—
you explain the theory behind each
Sure.
of
The
those?
theory is through a line of cases that deal with construction. We point to the Kaiser cases, the Jacobs and Young v. Kent cases, the Justice Cardozo case. In those construction cases, when there's an intentional deliberate breach by the breaching party, the court awards cost to cure damages. And the purpose behind that—
And that's appropriate even if you're not seeking specific performance?
So we did seek specific performance here initially when the court—
But you're not still, but you—
We couldn't because at the TRO level, what we really wanted was the matching brick. We don't have that now. But when we found out that non-matching brick was going to be installed, we filed a TRO application immediately. And we went and we were told, this is law of the case here, we were told we can be made whole with money. We can't stop them from building. And so based on that, this is Justice Edmeade—
You didn't appeal from that, right?
Sorry?
You didn't appeal from that, right?
There's no appeal. There's no notice of entry filed in that decision. But based on that decision, we relied on that to pursue money damages. And the basis for money damages comes from a case, how do we be made whole? Specific performance is no longer a viable remedy. What we have now is a 60-foot towering wall that was contracted for to have matching brick. We can't change that. So the best substitute, the best approximate value is to look at how do courts place a value on that when there's an intentional construction deviation. This was intentional. Now, I understand these line of cases, it's where the person owns the property, right? But in every one of those cases, the courts don't focus on, well, how are you going to use it? Are you going to use it to fix and remediate, or are you going to just, you're going to take it?
So
And
when we talk about matching brick, we're talking about the wall in the rear not matching the wall in the front, right?
Correct, Your Honor. If you recall, 4 years ago, I had a panel here,
Yeah.
and we were examining the different brick. It's a
I
different
don't think I like the brick on either the front wall or the back wall.
Well, Your Honor, that's the point here. It's
But that's when you talk about, matching, it's not like, this wall has one row of one color gray and another row of another color gray. It's the wall in the back versus the wall in front.
correct, but it was important enough to put it in a contract. It was
Yeah.
a bargain for aesthetic that
Exactly.
the parties bargained for. So right now, Chabani got what she bargained for. She was able to get access. She was able to construct. She now has a wall.
So she took she purchased the less expensive brick, right? I think.
Correct, Your Honor.
$1 something a brick.
It was $1.65 a brick.
As opposed to $5.99.
As opposed to $5.99. So there are two theories here. The best one is to follow the line of cases going back 150 years, and it's the cost to cure. That's how we make someone whole, especially
Those
when
line of cases deal with cost to cure when it's on that person's property.
they all do, Your Honor. This is going to be a first. And the point here is that you can't allow an opportunistic breach here. You can't just say, well, we decided to breach, we decided to choose a cheaper brick, and we're going to get away with it. This is the message that you're going to send.
Why not make it whole by saying whatever was offset by going the cheaper way, then the amount of damages is to make it whole by putting in the rest to make up what it would have been had you used the brick that was bargained for.
Because that's not how these cases hold it. They say, look, if you breached it, we're
Those
going
cases have to do with cases where the breach is on the person's
It
property.
makes no difference here, Your Honor. It makes no difference because we have to place a value. We have to place an approximate value. And in all those cases, they tell the GC, look, even if it costs you more than what the contract price was, this is what we're going to award you in damages. These are the Kaiser cases we cite, the School of Elmira case, the Lyon case, the famous Justice Cardozo case. I understand it's a bit unusual, but it's consistent with the law, and it's how we have to place a value here.
Thank you.
Good afternoon, Jessica Rothman from Robinson and Cole for Fiona Chabani. I'm going to first address damages as counsel did, and as Justice Michael correctly pointed out, the cases cited by the appellant here deal with a breach of contract remedy between a property owner and his or her own contractor. You hired, in the Kaiser case, they hired a contractor to build a house and did not get the benefit of that bargain. I want to be clear.
So let's be clear. That's what we're talking about here as well. We're talking about the benefit of the bargain.
It's not, though, because the bargain here, this stems from an RPAPL, a license agreement for Ms. Chabani to gain access. I understand, including the justices here today, found that Ms. Chabani intentionally chose cheaper brick. I am sure you can imagine we vigorously dispute that.
Well, that's a little, that's.
I agree.
I wouldn't waste a lot of time on that. We've already decided that.
It's significant because, as it relates to damages, nominal damages exist for a reason. This court found there's a technical breach, and we're stuck with that. But Judge Bannon sat through a trial before this decision, your decision, was issued. We were on the last day of trial.
I don't recall that our decision said it was a technical violation.
No, but they found, I said an intentional breach, that she chose, this court found that she chose non-matching brick.
Right.
This is a landmarked house. The brick had to be, match showed up in the license agreement because the brick had to match because Landmark said so. And the house is built with the brick that Landmarks approved. Landmarks found it matched. Here, nominal damages, what they're seeking is not compensatory damages. The proof they put on at trial was with Ms. Stammel, Crown's principal's testimony, that she doesn't like looking at it.
So wait, I didn't see anything in the record from Landmark saying that the bricks matched.
So there is testimony that the brick being installed is what was approved by landlord, and I can, well, I don't
By
have-
landlord or landmarks?
By landmarks, I'm sorry. The
That would be
architect
hearsay, wouldn't
testified
it?
at trial.
That would be hearsay. There's no document from landmarks.
That's a fair point,
so-
because what's also hearsay is the proof relied upon by the appellant. They put on, after begging, and I'll tell you what they asked for in the complaint, which is none of what they asked for here. What they asked for in the complaint is not, even in part, what they asked
So,
for.
counsel, again, we need to focus here. The bricks do not match. That is clear. They don't match.
This court found it doesn't
We have
match.
so found that
Correct.
okay, so they do not match. So now the issue is damages.
Correct.
Okay, so how are the damages to be calculated?
Nominal damages are appropriate because the damages being sought are not compensatory, they're punitive. There is no amount of money, which was confirmed by Crown's own witness at trial, that can compensate them for the lost benefit of this bargain. The cost of the bricks, if Ms. Stammel could buy those bricks, she's not gonna buy them because she can't do anything with them. The
So I have
wall
another
is my
question for
client's
you.
house.
I have another question for you. So there's also another request. I believe it's 40,232 bricks at a price of $599. Now, that figure is from the entity that your client sourced. So why wouldn't the 240,989 be inappropriate here?
For two reasons. The witness who testified at trial, Mr. Liebhaber, said he prepared that estimate at the very specific direction of Mrs. Stammel. He doesn't know where the quote came from. He doesn't know that the brick matches. He doesn't know that it can actually be used to build a wall. He never even saw the wall. He testified to that at trial, and I personally cross-examined him. That is his testimony, and it's in the record.
You
Mrs.
cross-examined
Stammel.
rather lightly, didn't you? It was a very
Sorry?
it was a very brief cross-examination.
No, it was
Mr.
not.
Lieberhaber?
I don't think it was very brief, but he did directly answer the questions that he took a quote, he does not know where it came from, the quote was not in evidence. Mrs. Stammel, the principal of Crown, gave him a quote and said, prepare a quote to brick a wall of these dimensions. He never
Well, he
saw
says that in formulating the estimate as to the brick price, he considered a proposal from Stone Art, the company that Chabani had contacted for a custom brick quote. And he also relied upon his pricing knowledge from other jobs, and he also visited the property approximately 15 times.
That is incorrect, and I'm sorry to say that, but he said
That's
he
not what he
never
said?
visited Chabani's
I'm looking
property.
record 433. That's what he says.
I have another question, so maybe you can answer both.
Yes.
So, okay, you're saying it's incorrect. So since it was incorrect, did your client put in any evidence to challenge that?
Yes. First of all, Mr. Liebhaber was disclosed for purposes of settlement, and I understand my time is up, but it is important that the remedy being sought here is not what was sought in the complaint, and that was another reason why nominal damages were.
So what was the remedy sought in the complaint?
In the complaint, they sought the cost of building a wall on their own property. This wall that we're talking about is on my client's property. The complaint seeks a wall so Ms. Stammel doesn't have to look at my client's house, plus the lost property value that that wall will presumably occupy. That's what the complaint seeks, and that's what was there when I prepared for trial. And
So should we direct it there another wall be built?
she can build a wall on her
Using the
property.
proper bricks at $5.99 per brick.
No one testified that that brick matches. There's no proof that that brick would have been
So,
appropriate.
but counsel, again, we have already ruled that the bricks do not match, okay?
I'm stuck.
You're stuck with that. So your client spent $66,000 approximately to erect this wall with the bricks that don't match, or $66,000 for the bricks that don't match.
I cannot confirm or deny the cost.
Approximately.
I would imagine it's more.
Wherein if she had used the bricks that do match, it would be a little over $240,000.
There's no proof that the bricks that this plaintiff is looking
Let's
for match.
assume that based upon the calculations in the record, why then would your client not have to at least be assessed damages for the amount that she would have paid and arguably should have paid for the bricks that matched?
Again, Your Honor, there's no proof that the brick that's the basis of their estimate matches.
Putting aside that, answer the question.
Because it's punitive and a windfall. They can't do, that doesn't restore
Why is
them
it
to
punitive
anything.
and not in response to the bargained for deal that didn't happen, right? And the bargain for was permission to use the property to erect a wall on your property, but that a caveat was that the bricks match. That didn't happen.
What didn't happen is they didn't use Crown's property to build the wall.
Okay, so we're back to the fact that this court
That didn't
already ruled
happen.
that the bricks don't match. So again, the fact that your client used bricks that do not match, should there not be some consequence for the fact that your client intentionally used bricks that did not match?
Okay. I suppose there could be a consequence, but that would be a fine.
There could be a consequence. There
It
should
would
not be a
fine.
consequence. Okay, so what would the consequence be for intentionally not using bricks that match when you're supposed to use bricks that match? What would the consequence
It's
be?
a difficult question to answer because Landmarks approved.
This is an easy question that I'm about to pose because it's only a yes or no answer. So this is very easy. Did your client put in any evidence to challenge plaintiff's expert calculations? That's a yes or no?
Yes.
Okay, one more. That's real easy. The page number in the record where the opposing proof was set forth.
Can I give you a two-part answer?
2 pages?
Yeah.
One is in the testimony of Marc Albertin.
What
The
page?
second one, and counsel will agree, our expert was scheduled to testify at the moment we got the decision. So Judge Bannon didn't let him testify because you made your finding on liability.
It's a little more, but okay.
Thank you.
I want to explain why it's not there, not because we didn't put it on.
Justice
It was
Gesmer has a
present.
I have a
question.
very small question. You keep talking about Landmarks saying, approving some bricks, but I thought we agreed earlier that there's nothing in the record in front of us from Landmarks, correct?
No, except for the
No, no.
testimony.
Is there anything in the record before us from
testimony of Marc
Landmarks?
Albertin.
No, no, but that's testimony from a person not at Landmarks about what Landmarks said. That's
Yes.
hearsay. Is there anything from, am I correct that there's nothing from Landmarks, notwithstanding the fact that you keep talking about what Landmarks approved?
The Landmarks approval for the project is in the record.
In what record?
On this appeal.
From Landmarks or testified to by somebody not from?
The actual Landmarks record that says the brick has to match, which is what became the basis of.
Where is
the
that
agreement.
in the record?
I have to find it.
Thank
It's
you.
in, the document from Landmarks is in the record.
Thank you.
It's a trial exhibit.
And that's in the record before us?
If I may, Your Honor, the 240,989. That's from a document, King's brick document, that her client got. Number of bricks, 40,232 bricks, $5.99. That's the stone art estimate that her client procured, number one.
Maybe that's why they didn't put any evidence since it was.
Perhaps. Number two, we have Andrew Liebhaber's proposal. This is the expert that we submitted. We gave 4 months advance notice. We put it in our client's witness list. We submitted the proposal. Liebhaber testified, 27 years experience, Crown's representative, visited the site over 15 times, has extensive experience renovating, replacing, and installing brick. What did they put in response? Nada, nothing. There is no rebuttal expert. As far as producing an expert on the, when this decision came out, this decision was on liability. Damages, you could have still put in an expert.
Is
They
there
had
something
three
from,
more.
was there a trial exhibit from Landmarks concerning the bricks?
No, no. There may have been some landmark submission in there that, you know, when you do this construction has to match, but that's besides the point. We have a contract that's independent from whatever Landmark said, saying we care.
Did Judge Bannon make any reference? I didn't see any reference, but
I
did
don't
she
recall.
make any reference to
I don't
Landmarks?
recall any reference. There's nothing in the record that I can recall. The bottom line here is we have two parties. They contracted. It was highly important for my client to, when they go out of their rear yard and they look at this towering 60-foot wall, that they have matching brick. They didn't get it. They did not get it. So what are we going to do?
The matching brick, the brick doesn't match in the front, the brick in the back. So.
It had to match the facade in the front. We haven't even gotten to this, but
But your adversary also states that in your complaint, you asked for the wall to be built on.
So, right. So in the complaint, we pled and sought money damages. It's in the indictment clause. We also, throughout our briefs, when it was summary judgment, on appeal, at trial, post-trial memorandum, we made it crystal clear we want cost to cure damages. Also, at trial, we have CPLR 3225. You can conform the pleadings to the proof that was submitted. The proof that was submitted, Andrew Lee Paper's proposal. That proposal is $646,000, which is the cost to cure. I haven't even touched on attorney's fees, but I don't know if you want to go into there, but we're talking about a 90% reduction that doesn't even cover the expenses here.
Thank you. Thank you
Thank
both. Bova versus Paramount Leasehold.
May it please the court, Brenda Fitzpatrick, counsel for the appellant respondent, Cord Contracting. Your Honors, I ask the court to reverse the Supreme Court's decision and dismiss the complaint and all cross claims against Cord, which is merely a subcontractor hired to supply carpenters to Shawwitt so that they would do work specifically as directed by Shawman. And what we have here is, at first, Cord put down protective flooring at the Hard Rock Cafe. They put down a ½ inch of homosote, which is kind of like a foamy styrofoam material, and then 3/4 inch plywood on top of it, all secured by flat stocks. Then, on March 24th, 8 days before the accident, Shawman calls up Cord and says, send another carpenter over, we need some additional work done. Mr. Amato goes, he specifies the work that Shawman asked it to perform. Our Hard Rock Cafe wanted its workers to have access underneath the scaffold that was placed in the Hard Rock Cafe at Times Square. So what Mr. Sinatra said from Shawman, he told them where this was supposed to be, where the pathway was supposed to lead for the Hard Rock workers. So Mr. Amato went through everything that he did that day. And this is detailed in his affidavit and his testimony. What he did was he undid the flat stocks. He lifted up the plywood. He cut out several feet of the ½ inch sheet of homosote that was underneath that one section of plywood. He beveled the edge of the plywood. Then he laid it back down, the plywood, and the edge of it laid flat or flush. He used both of those words interchangeably through his testimony and his affidavit. So it was flush. Then he secured it with a flat stock. So at that point, Mr. Sinatra of Shawmut, they both tested it. Mr. Sinatra inspected it. He approved it. Cord walked off the job because there was nothing left to do for them. And for 8 days, according to Mr. Martinez of Hard Rock, hundreds of Hard Rock workers used the pathway, went underneath the scaffold thousands of times without incident and complaint. So therefore, when Cord left, we established that when Mr. Amato left on March 24th, which was 8 days before the accident, there was no tripping hazard. It was flat.
Did you establish whether or not Cord followed the specifications set forth in the contract concerning that plywood?
Yes, but what we were supposed to do for this portion of the flooring, according to Mr. Amato, Cord was supposed to send a carpenter to basically do anything that Shawmut told him to do. And that's what Mr. Amato testified to without debate. So when they went there that day, Shawmut said, okay, bevel the edge. So he beveled the edge and made it flat. made it flush. There was no debate that this was improper, this was unsafe, or anything.
Were there any plans that were submitted or any plans that were followed in terms of the plywood, the flooring?
I don't believe for the actual flooring when they first
For the work that court did?
for the work on March 24th,
Yes.
no, I don't believe that any plans honestly needed to be performed. You're talking about a remedial measure to make it flat, and we did make it flat. So when plaintiff comes in his brief, and pages 7, 10, 11, and 12, and specifically page 12 of his brief says, I tripped on a 2-inch differential between the plywood and the floor. Court didn't create that. And court proved that it never created any kind of a 2-inch difference between the plywood.
And you proved this based upon?
Based upon Mr. Amato's uncontested testimony as to what he did. Now, plaintiff in opposition, initial opposition, says, well, he actually said it was Mr. Amato said it was actually raised a 1/2 inch. Mr. Amato never said it was raised a 1/2 inch. Mr. Amato said what he did was he cut a 1/2 inch, the 1/2 inch homosote out from underneath the plywood. Therefore, there was a gap underneath the plywood and the main floor. That's all he said. He said it laid flush, and there's no debate about that. But in their subsequent brief in reply, plaintiff says, well, now his affidavit contradicts his sworn testimony. But that's not true either. Because if you look at pages 1191 to 1195 of the record on appeal, where plaintiff's attorney is specifically questioning Mr. Amato about a diagram Mr. Amato drew at his deposition to try and explain to these attorneys what he actually did, I believe page 1192, plaintiff's attorney asked him, well, how do you explain how the plywood gradually slopes down and becomes flat? Mr. Amato explains, yes, that's how you do it, because I beveled the edge, and because I cut the homosote out from underneath the plywood, it rests down gently and becomes a gradual slope. That's what he testified to. There was no dangerous condition when we left the condition.
Thank
when
you.
we left the property. Thank you, Your Honor.
Good afternoon. May it please the court. Mark Walsh for the plaintiff's respondents appellants. The lower court properly denied the court's summary judgment motion. The current argument on appeal, this Feeney-Ryan case, it's a 1924 decision from the Court of Appeals. It's been cited to a number of times, and the argument just raised here defeats the citation he makes to that case. He says that this type of work that was performed in the modification of the temporary flooring didn't require plans or specifications. Well, Ryan v. Feeney says that plans and specifications that a contractor is obligated to follow pursuant to the contract they enter to build a structure can absolve them from liability if the defect in what they construct is so advanced that a regular lay person contractor wouldn't understand it. This doesn't apply here. This court has ruled many times in its progeny under Espinal and every case that's followed it that a subcontractor who launches a force of harm or instrument of harm can be found liable. By installing this temporary flooring and subsequently modifying it in the way that he did, creating a springboard or diving board of sorts by removing 2 feet of homosote underneath it without fixing it in any way, expecting us to believe that a wooden board that's 3/4 of an inch thick would gradually slope down like a wet noodle is not established through the evidence.
We have no complaints. We have individuals walking on it and no issues, no complaints.
We have no proof of complaints in that, and we are not contesting here when we move for summary judgment on behalf of plaintiff that we have proof of actual complaints, but they don't have proof that they didn't receive complaints. They have 3 witnesses, 1 for Shalmut and 2 for Cord, who testified that they have no either independent knowledge or personal recollection of whether or not complaints were received. Also, they couldn't recall whether or not they were working on the subject date in question. There is a case from the First Department of Val Verde that says if your witness does not recall whether or not he even worked on the date in question, he cannot provide prima facie evidence as a testimony of complaints. But they say that they don't recall, and 2 of them even said that they would not have been the individual to who those complaints would have been directed to. Those would have been a William Cochran, whose testimony is unavailable and not before this court in the record. So it's not that there was no complaints, there's no knowledge of complaints. And as far as constructive notice, there isn't a scintilla of evidence as to whether or not this subject location had been inspected at any point from the installation of the floor up until the accident. A few witnesses testified very vaguely as to something that almost reaches usual and customary practice, but even then they said that the usual and customary practice expected of us was to do inspections. And when the follow-up question was, well, did you follow that and did you do those inspections? It was some combination of I can't recall or I don't remember or something of that sort. So the court properly denied summary judgment there. As far as summary judgment goes on behalf of the plaintiff, the testimony of the witness, Amato, who installed it, is clear. It's that the defect was made, there was a gap. He testified all that clearly. That's contained in the record. This court is more than able to read that themselves. So with that stated, the defect existed from the time it was installed, March 24th, and modified until April 8th, the time it existed. That's almost 2 weeks. 2 weeks during which no defendant here can establish by any measure of any evidence that they inspected that location, and upon inspection that they would have found it and been able to fix it because they were able to put down cautionary tape that just said, hey, be careful, there's a tripping hazard here, not actually correct it, within 90 minutes of the accident happening. So if you take Amato's testimony that a gap existed and you understood it the way I've presented it, and then you take the fact that they can't show that they've done any inspections of the sublocation whatsoever, and the defect existed, the half-inch Amato testified to is the same half-inch his co-employee Martinez testified to, who is the only witness to have actually observed the accident with his own eyes, a point of testimony that is overlooked by the lower courts and the defendants in this action. He testified equivocally or unequivocally and irrefutably to having observed the accident, having observed his foot hit the board, and then having observed the board be a half-inch raised above the ground. And if you take all of that, the plaintiff has established that core defendants created a dangerous condition, that the remaining defendants who had duties otherwise as owner or general contractor failed to correct within the 2 weeks' time that they had to discover it and remedy it.
Was the plaintiff's testimony clear about what caused the accident?
The plaintiff's testimony was clear if you take into account the fact he testified over 4 days for 16 hours and he's a non-English speaking Albanian. This court has ruled in precedent and has taken into consideration certain precedents that a witness's testimony who might not be the most clear, and there are some ambiguities as to their testimony, they have taken into account a witness who speaks English as a second language or is testifying through a translator, such as the case here.
Thank you.
May it please the court, Your Honors, David Holland from the Law Office of Eric Feldman. I'm here on behalf of defendants respondents Paramount, Levin, and Shawmut. Plaintiff's counsel just spoke a lot about the lack of proof as far as when the last inspection of this particular area was done. What he left out, however, was that in order for that to even matter, the alleged defect has to be readily discoverable upon a reasonable inspection. What we have here, and what was not mentioned, is that not only had the plaintiff in that ensuing 2 weeks walked over this area at least 1 to 5 times per day, had inspected the flooring up to that beveled edge, and admitted that he never saw any type of height differential. We also have the testimony of plaintiff's co-worker, Mr. Martinez, who said he walked over that area 100 times a day. This is not an exaggeration. 1,000 times in the prior 10 days before the accident, he had actually passed over that area. Not once had he seen any height differential. Not once had he felt any deflection in the wood. In addition to that, there are 100 other co-workers of plaintiff at the Hard Rock who that area was open to. There's no evidence anywhere of any complaints or any other accidents. So we have actual testimony from plaintiff and his coworker that they not only inspected that area, but they actually passed over that very area where they're claiming this half-inch differential existed, and there's no indication they saw it or observed it prior to the accident. It's only after the accident, after plaintiff's body falls on the wood, that Mr. Martinez first says he sees that half-inch differential only in that very specific area, not along the length of it. So the proof is rather clear here that there's simply no constructive notice because this was not readily observable upon reasonable inspection. If 1,000 plus times this had been walked over, stepped on by the accident, and no one noticed this, up until the very morning of the accident, plaintiff is approaching it. He says he's looking down at it. He does not see it. Mr. Martinez is approaching it. He's looking down on it. He does not see it. It's only until after the accident, after plaintiff lands on it, that he says there's some deflection in the wood, and that's when Mr. Martinez sees for the first time that there's that half-inch differential. As far as, I just want to touch very briefly on Mr. Amamoto's testimony. I think there was some clarification there as to what he said about that gap. What he testified to was that the styrofoam was here. It was cut away underneath. The gap he's talking about is under this area. He's absolutely unequivocal that this area is beveled at 45 degrees and it is flush touching the ground. That is undisputed by any witness. If I can really pivot very quickly to the other appeal, that's on Cord's motion to dismiss the contractual and common law claims. If this court is to find that no defect even existed, that's a moot point. If Cord is kept in the case, obviously the contractual and common law claims against them should not be dismissed. Thank you, Your Honors.
Thank you.
Thank you, Your Honors. Plaintiff is now saying that this was a springboard or a diving board. In his brief, page 7, he says he fell on a raised plywood board.
Well, was the plywood affixed to the ground at all, to the flooring?
No, there was not. It was actually a large. It basically became a large, static piece of protective flooring.
Right. So their argument was that it wasn't affixed, and also that whatever was under it was not stable enough to support the plywood. Right.
Your Honor, Mr. Amato and Mr. Sinatra walked on it. It was approved. There's nothing anywhere that says that whatever we did was improper. And again, as this court notes, as the undisputed testimony is before this court, hundreds of people walked on it thousands of times without incident. We did not create any dangerous condition. He did not trip over anything that Cord did. When Cord left the site that day, it was safe. And the thing is, we did leave. There's no debate that Cord left on March 24th. What plaintiffs are arguing is that Cord should be held responsible for anything that happens after that. Even though we didn't own, control, possess, or maintain this property, even though we had no authority to control the property or maintain safety conditions, according to plaintiff. This case should be akin to the decisions from this court in Faraggia, Hewlett, DeMaria, and Balbuena, all of which this court specifically found that it was undisputed that the subcontractor created the condition. In contrast, what we have here is we have Mr. Amato testifying without debate that it was flush. It was flat with the ground. There was no tripping hazard when Cord left. Therefore, under Espinal, under Feeney, under this court's decisions in Vargas, Rappaport, the second department's decision in Greenstein against Real Life, Turner against Trader Joe's, and Rogers against City, when a subcontractor performs its work in accordance with directives from the contractor, and that work is approved, and there is no dangerous condition created, they are entitled to summary judgment because they are not the enforcers of safety at a construction site, especially when they have left for 8 days.
Thank you.
Thank you, Your Honor.
People v. Jamal McPherson.
Yes, a minute.
Oh, I'm sorry. You have a rebuttal. I appreciate it.
Addressing just a few points here in rebuttal, the latent defect argument, as I put in my brief, newly raised argument, first time on appeal. This is the first time I'm hearing it. We're sharing it there in the same boat. The words latent do not show up in the underlying papers to the Supreme Court. There's no argument that's latent. They raised that argument for the first time on appeal. That should be rejected by this court and following the precedent of Cowell-Zeke v. Time Warner Entertainment. I apologize if I butchered that first name. As far as the frequency of walking over the defect and the fact that someone hyperbolically stated, Mr. Martinez, that he had walked over it 100 times a day and never noticed the defect, he also testified very clearly and succinctly in the record that while his job entailed him inspecting Hard Rock's floors, that he stopped inspecting that location where the temporary flooring was placed because that was not his duty because he had nothing to do with the ongoing construction. His inspection of the floors ceased the moment that floor was installed. It was not his duty or job responsibility to inspect that. He is an employee of Hard Rock and a coworker of the plaintiff. The court seems to have overlooked that, and everyone else overlooked that.
Thank you. People v. Jamal McPherson. Whenever you're ready.
Good afternoon, Your Honors. Kristen McGlobby of Legal Aid Society, practicing as a law graduate under this court's study practice order on behalf of Jamal McPherson. In light of serious physical and mental health challenges, the unnecessary risks probation presents, history of commitment to his community.
Probation will be terminated April 2024. So we're only talking about a couple of months, right?
That is correct. However,
So he's already completed over 4.5 years, right? Just over 4.5 years of probation. Why not just proceed to April 2024? And I'm assuming he's not reporting, every day. He's probably just going to a kiosk or just reporting like once a month or something of that nature. Why not continue the supervision for a couple more months?
so as highlighted in the less is more reforms, which speaks particularly to parolees and not probationers, although the issues there are similar, lengthy probation sentences pose unnecessary risks of incarceration or reincarceration for people who are on probation. The high risk of incarceration for small violations or technical violations, coupled with the gravity of Mr. McPherson's health conditions, which include a disability and a chronic autoimmune disease. So those together are sound reason for this court to reduce the remainder of Mr. McPherson's probationary sentence. Mr. McPherson, along with being diagnosed with a chronic autoimmune condition, was rendered disabled and reliant on public assistance leading up to the instant offense. Mr. McPherson had worked very hard in the past as an HIV group facilitator and counselor, and he showed a devotion to people struggling similarly to himself in his neighborhood where he was born and raised in the Bronx. I'd also like to point out that there was no violence used in this offense, and Mr. McPherson freely admitted to his wrongdoing and has shown a sort of appreciation for the harm that he has caused. And so remaining on probation,
I was very sympathetic when I was reading when I read your brief, because I thought, oh, well, he just took a check and it was made out to a business. It was not made out to an individual. He came upon this check and, he just deposited the check and cashed the check. Then I read the people's brief, and it was very elucidating because apparently he removed it from the mailbox. So that means that he what is that called?
Fishing.
He fished into the mailbox and took that out. So maybe he took other pieces of mail as well. He created a fictitious business account so that he could deposit the monies into that account and then therefore draw from that account for $19,344. There was no indication that he was using this, because you stated that he was on public assistance, that he used this for any, sundries or food or anything of that nature. But it seemed to me that this was somewhat sophisticated, far more sophisticated than I realized when I read your brief.
I believe that the conditions that Mr. McPherson was under largely informed his actions, particularly because he has...
I wouldn't know how to put together fraudulent documents in order to set up a business account at a bank, and then I don't even know how to fish in the mailbox, to take the letters out. And also, I thought that was a federal offense, and I was surprised that the feds didn't take it. So I thought this was probably a pretty good deal, wherein he was only sentenced to 5 years probation as opposed to a federal sentence. But anyhow, you have time on rebuttal. Thank you.
Thank you.
So it's 5 more months. What's the big deal?
Yes, Your Honor. Good morning, good
Afternoon.
Almost evening. Jacob Marcus for the people.
No, it is 4:10. Okay, evening is 5 o'clock. We go through this every day. Please do not rush the day. Go ahead.
Jacob Marcus for the people. To your question, what's the extra 5 months? I believe that the people best positioned to determine what the appropriate sentence here were the people most familiar with this case, namely the sentencing court, the trial ADAs, and the defendant himself who agreed to this sentence. The defendant was looking at up to 7 years on the originally charged Class D felony. That's the maximum term. And instead, he managed to avoid any form of incarceration at all, pleading to a deal that allowed him to reduce that D felony to an E felony, 2 E felonies, excuse me, and do 5 years on probation. So I believe that we should defer to the fair, certainly not unduly harsh or excessive decision made by the trial court and accepted by the defendant when he took this plea, and not disturb it on appeal. I'll also note that there is an appeal waiver that the people contend was knowingly, voluntarily, and intelligently made. So on that basis alone, because it precludes excessive sentence review, this court shouldn't review it at all. If Your Honor, thank you.
I'd like to address the appeal waiver as well. The lower court's language of finality and the misrepresentation of the scope and effect of the purported appeal waiver renders this appeal waiver invalid, and thus gives this court the authority to review the excessiveness of this sentence imposed upon Mr. McPherson. Additionally, speaking to the 5 months that are remaining, I believe that these 5 months pose unnecessary risks for somebody in Mr. McPherson's particular position as somebody who is disabled and who has a chronic illness that needs to be maintained very regularly and that has to follow a structured medical regimen. And in light of Mr. McPherson's situation leading up to the incident fence, I think it's particularly sympathetic to see that somebody who was struggling financially, struggling with their health mentally and physically, just made a mistake and has owned up to it since and has, stayed on the correct path of the law since.
Thank you. You just graduated in July?
I graduated last year.
And so you're awaiting admission?
I'm awaiting admission, yes.
Well, good luck. In the first department?
Yes.
Oh, okay. So we'll see you back here for the admission ceremony, and good luck. That was a great argument. Thank you very much. Thank you. Wojcik Law Firm versus Mal. I messed it up again. You told me how to say it, and I did it again, didn't I? Wojcik. I'm just going to say Law Firm versus Mal.
I'm just going to say appellant. Good afternoon, Your Honors. May it please the Court. Adam Sakowitz from Katz Mellinger PLLC, representing the plaintiff appellant respondent. This case involves a breach of a personal guarantee of a corporate debt for legal services rendered. The IS court correctly determined that the guarantee applies to both the past due balance and the new charges under the 2017 services contract, but erred in finding that issues of fact exist as to respondent's affirmative defenses. While respondent does attempt to raise issues of fact as to those affirmative defenses, respondent offers no evidence in support of his defenses, instead relies on conclusory allegations in his affidavit, which, even if the court accepts as true, are simply insufficient to meet his burden of establishing his affirmative defenses as a matter of law. The IS court should have rejected the defenses and granted summary judgment in favor of appellant. For instance, respondent alleges undue influence as one of his affirmative defenses, and specifically alleges that Mr. Wojcik, the principal of appellant, took advantage of a distraught, emotional respondent based on his company's dire financial situation. However, respondent offers no bank statements, no financial reports, no business records of any kind showing this alleged financial distress, or offer any specifics in an affidavit as to the extent of this financial issue. Nor does respondent submit any medical records, a note from a doctor, even an affidavit from a friend or a loved one attesting to his alleged emotional distress. As the court made clear in King v. Fox, emotional distress does not equate to incapacitation, and without evidence of incompetence, there's no material fact presented that can establish undue influence as a matter of law, and therefore that defense should have been rejected on summary judgment.
And there was some indication that he was also a sophisticated business person, and he had retained other law firms to do work as well?
Correct. Respondent was operating 3 businesses. He had retained at least 2 other law firms at the time he entered into this contract, in addition to appellants. Shortly thereafter, retained a 3rd law firm, was involved in deals worth hundreds of thousands of dollars, was involved in arbitration. Certainly And that speaks to the unconscionability affirmative defense as well.
He also wasn't too distraught to negotiate a cap on his monthly payments to your client, as I recall.
Correct, Your Honor. In the 2017 services contract that respondent paints as one-sided, there are credits, there are discounts, there was a subsequent agreement for deferred payments. There were multiple concessions made by appellants to try to make this situation work. Additionally, the 2017 services contract itself contained an express acknowledgement that respondent agreed and understood terms, and that he either consulted with counsel or voluntarily assumed the risk of not doing so. Respondent also portrays Mr. Wojcik as pressuring him into signing this agreement. It's important to note that this agreement was dated February 1st of 2017. The arbitration that respondent was involved in and worried about, the hearing wasn't until late August, almost 7 months later. Based on respondent's resources, his knowledge, his experience, his education, he had options. He had other attorneys to turn to. He could have resolved this issue with appellants. He had options. This was not a case where he lacked meaningful choice and was not fully informed of the terms of the contract, which are required to prove unconscionability. If the justices have no further questions, I'll reserve my time for rebuttal.
Thank you.
Good afternoon, Your Honors. May it please the Court, Michael Anton Giovanni, Myers Schweiz, English and Klein, for the defendant, respondent, appellant, Andrew Mull. Your Honors, the lower court erred in denying Mr. Mull's cross motion for summary judgment, as the record reflects that this purported guarantee was the product of undue influence, and even if it was a valid guarantee, it did not retroactively cover past debt, and that the debt that it did cover, if it was valid, has been paid in full. As the record reflects, Mr. Wojcik and his firm caused Mr. Mull to execute 5 fee agreements over the course of 3 years with increasingly complex and lopsided terms that are in favor of Mr. Wojcik.
Your client was a businessman who negotiated contracts with other law firms as well, and seems to have negotiated some clauses that were pretty favorable to him. So I have trouble understanding exactly why you're viewing this as having been imposed on him.
Mr. Mull was in his late 20s at the time. This was an evolution in terms of the business, and Mr. Wojcik went along with it as a trusted advisor. So in the very beginning, he didn't have 3 companies.
When he entered into the fee agreement in 2017, even though he owed a lot of arrears, they were willing to cap his monthly payments. I thought that was extraordinary. Your client must have done a really good job of negotiating that, I would think.
No, Your Honor, because the 2017 agreement was the product of the undue influence that Mr. Wojcik was exerting over Mr. Mull, and he had threatened Mr. Mull by persistently advising him that his testimony and cooperation was critical to that upcoming arbitration in August, and that he did not accede to his requests. And the requests were a personal guarantee by Mr. Mull, which he had no obligation to do so. Also, there was an 18% interest rate in the retainer agreement.
And also discounted hourly rates, as I recall.
I'm sorry?
And also discounted hourly rates.
There were some minor discounts, yeah, but he also had him acknowledge the $270,000 debt, and right after he signed that 2017 retainer agreement, never sent him a timely invoice after that. He waited 6 months to send him invoices, and that was his pattern and practice. He would send him tranches of invoices so that he could never assess exactly what was owed, okay? So you had a situation where he was, and he does not deny this, by the way, but that he was persistently suggesting to him that he needs his cooperation to prevail at this arbitration, which was a bet the business arbitration, okay? Because he was in financial straits and he was under severe emotional distress, as his affidavit reflects. They do not contest that.
At that time, he had access to other attorneys helping him with other matters, right?
He did have access to other attorneys eventually with respect to the business. Again, this was an evolution, not in the very beginning. And these agreements were progressively more in favor of Mr. Washik, including 4 months after the 2017 agreement, he has Mr. Mull enter into an employment agreement because he can't get a mortgage on his own house. So he wants to show steady income. So he has this employment agreement drawn up. This is the fourth agreement in 3 years that he has him sign. Okay, this is in favor. This is a personal interest of Mr. Washik. I see I'm running out of time. I just want to get to my next point. If you have no other questions on the undue influence, but the second point is, if even the guarantee were valid and was not the product of undue influence, it does not guarantee prior existing debt. That is clear. Guarantees are construed narrowly, and they will not be held to cover prior existing debt unless it's expressly stated in the guarantee or it's necessarily implied by the circumstances. Here, this is a one-line guarantee embedded in a signature page of a 12-page agreement. It says nothing about guaranteeing pre-existing debt. In fact, it says, that agreement says it supersedes all prior agreements. So it created a new relationship at that point for the scope of the services defined in that agreement. And the scope of the services were for continuing matters and corporate matters that were ongoing. But it was only, if there was no indication that this was going to guarantee anything other than the current scope of services. And those services were paid in full. Under the terms of that agreement, all the payments that were made for new work were applied to new work.
Thank you. Your time on rebuttal.
Sorry. Could you address the last point made by counsel about whether or not the guarantee covered pre-existing debt?
Absolutely, Your Honor. So, as the lower court properly found, the guarantee does apply to the pre-existing debt, not because the guarantee applies to the prior agreements. The guarantee should be narrowly construed. What the guarantee says is that the guarantee covers the company's obligations under the 2017 services contract. That 2017 services contract expressly refers to the $273,000 past due balance and obligates the companies to repay that debt. So since the guarantee covers the entirety of the 2017 services contract, and the 2017 services contract includes an obligation for the companies to repay that prior existing debt, the guarantee applies to that prior existing debt because it's stated in that document. As to the employment agreement, which respondent refers to as the fourth successive fee agreement, it's important to note that, first of all, respondent had counsel specifically negotiate the terms of that agreement on his behalf, outside employment counsel from one of the top employment law firms in the country. So to argue that the terms of that agreement were unconscionable doesn't make a lot of sense. And also, the reason for that agreement was to benefit the companies, to provide them with monthly amounts that they knew they would have to pay to appellant for all services, rather than getting invoices of different amounts, depending on how much work was performed. The last point I want to briefly touch on is respondent's claim of negligence. Specifically, negligence requires proximate cause and damages. This entire defense is premised on the idea that appellant's attorney's fees were not awarded in the arbitration because of supposed negligence by appellant. That's not what the arbitration decision says. The arbitration decision explicitly says that the reason appellant's attorney's fees were not awarded in the arbitration were because litigation counsel sought them as prevailing party attorney's fees and not as substantive damages. And since respondent can't connect the alleged negligence by appellant to the failure of the arbitrator to award attorney's fees, he cannot sustain a negligence defense.
But I want to go back to that 2017 letter, because if we look at the last sentence, and I'm going to paraphrase it, right, that, the individual signing, that they're going to be liable for the expenses incurred in connection with the engagement. And the engagement says, the ongoing dispute, et cetera, et cetera. So to me, in my mind, ongoing means the future, forward. What about that? Because it doesn't say anything about the past. So can we talk about that a little bit?
Absolutely. So I'm looking at a different portion of the 2017 service contract, and
But
specifically
the one that I'm referencing, that's what I like to stay on.
Sure. So the
I
first,
know you know where it is. I know you know where it is.
I believe I know. So the first paragraph of the engagement letter says, this engagement letter confirms the terms under which Wojcik Law Firm.
No. Let's get right to the chase. Let's forget that. We know what it says. Let's talk about what I just referenced. I paraphrase. Let's talk about that last sentence, because that's all I'm focused on.
Can you direct me to the paragraph, please, just so to make sure I'm looking at the same language?
Okay. Each individual signing below, I think it's on page 37. So we're going to skip all of that, right? Shall be jointly and severally liable to the firm. Let's skip all of that for all fees and expenses incurred in connection with the engagement. And the engagement is then defined as the ongoing dispute, ongoing this, ongoing that, et cetera, et cetera, et cetera. They just use ongoing just throughout.
Right. So the paragraph that references ongoing is under scope of the engagement, but engagement is actually defined in the first paragraph on the first page. And engagement is defined
Ongoing, right?
Sorry?
Ongoing?
No. On the first paragraph on the first page under Dear Client, it says this engagement confirms the terms under which Wojcik Law Firm will agree to act as outside general counsel to the companies.
The scope of the work.
Right.
Ongoing. Okay, so I use a different term. So let's talk about that, the scope of the work.
Right. So the scope of the work does reference the ongoing disputes, but the engagement refers to all terms under this document, and that's what the guarantee covers. The guarantee references the engagement and references the entirety of the document.
Okay.
Thank you.
Thank you, Your Honors.
Your Honor, you're absolutely right on that point, and that's my very point. And just the fact that we had to have this whole exercise of what does this really mean just shows how convoluted this agreement. A guarantee shouldn't be this difficult to figure out. If the attorneys can't figure it out, how is a layperson supposed to figure it out? Okay, so you have a 12-page agreement here. If Mr. Wojcik wanted to have a clear guarantee, he could have devoted maybe one of those 12 pages to an actual guarantee that spelled out exactly what was being guaranteed, but he didn't do so. If you look at this is a joke. On page 39, this is embedded. This guarantee is a one-line guarantee embedded in a signature line.
Did your adversary say that your client had counsel during?
Not
for this one?
Not for this one.
So he had no counsel?
Absolutely no. And they put in retainer agreements. Oh, look, he's had all these other attorneys. Yeah, all those retainer agreements are for other matters, not for anything in relation to this. But if you're strictly construing this, again, it has to be, first of all, guarantees have, there's a number of rules of construction that work against Mr. Wojcik on this. First of all, he's the drafter. So any ambiguity here works against him. Okay, number two, it's an attorney-client relationship. This is in a fee agreement. The third one, by the way, so this is actually heightened review of this because of the potential for abuse of a client and the fact that you could take advantage of them. That's another one. And then you come to the guarantees. Guarantees have to be construed strictly and in favor of the guarantor, and it's to be construed narrowly, so it's not going to cover more than what they intend to cover. Here, as Your Honor noted, it says in that very sentence, you're going to be liable for all fees and expenses incurred in connection with this engagement, capital E. This engagement, if we go back to page 34, it says this firm will agree to act as outside counsel. They will agree going forward to act as outside counsel as described under the heading scope of engagement below defines engagement. So now you have to look at what the scope of engagement is to figure out what the engagement is. And that's where we get to the ongoing.
Goodbye. Thank you.
Thank you, Your Honors.
HSBC Bank versus Gford.
Good afternoon, Your Honors. May it please the Court. My name is Adam Weiss of McCalla Raymer, Liebert Pierce LLC. I represent the plaintiff respondent in this matter. This case involves a foreclosure of a $440,000
So what
mortgage.
is your position as to the Travers hearing, whether a Travers hearing should or should not have been held? I'm assuming you think one should have been held.
The trial court was correct in denying a Travers hearing. Here, the process server's affidavit constitutes a prima facie evidence of proper service. The appellant provided absolutely nothing to rebut that presumption. He submitted a conclusory and vague affidavit denying proper service. In that affidavit, he failed to specifically deny service. He failed to sufficiently deny that anyone else could have been present at that time. And
Well, he says no one else matching the description of the alleged service recipient was present on the second floor at the subject property at any time in June of 2019. He denied the process server delivered any documents to him and stated that he may have been in transit back from work at the time of the alleged service.
I would submit that is completely insufficient to rebut the presumption. He only denied someone matching the description the affidavit was there. He provided no evidence as to anyone else who may be living there. He didn't submit a lease. He didn't submit anything. He said he may have been in transit from work.
He also said in his affidavit that he was not served with these papers.
That's correct, and that's of no moment because service was pursuant to CPLR 3082, not 3081. So it doesn't matter if he was personally served.
He also says that there was nobody meeting that description who was at his home during that entire month.
Yes, but that he provided no proof whatsoever whether anyone else was there. So we have no way of knowing whether perhaps someone else
But that's why you
was
have a
close to
Travers
the
hearing.
description.
If he presents a prima facie case as to no one meeting that description having been there, why isn't that in fact the basis for having a Travers hearing?
Because he did not deny that anyone else lived there, so it didn't give us the opportunity, or the court, it didn't give the trial court the opportunity to determine whether or not perhaps they were slightly different in the description. He was arguing with respect to himself that there was a 4-inch difference in height. That, even if service could be rebutted in that manner, a minor discrepancy in height would be completely insufficient to warrant a Travers hearing.
But I thought he said no one else was present on the second floor on that date.
No, he only said that no one matching the description in the affidavit was. But are we supposed to just rely on his assessment that, you know,
No, that's why you have a Travers hearing.
Well,
I mean, do you have any case law that supports that where the persons on whom service was supposed to be made puts in an affidavit with this degree of specificity that a Travers hearing is properly denied? From our department?
If I may, Your Honor, we do have.
I thought your brief was had a lot of second department cases, but very few from our department.
That is correct, Your Honor. But we did submit some first department cases. For example, FDIC v. Evangelista 22682D208, where holding that minor discrepancies in height at the time of service are insufficient to require a hearing. Appellant submitted absolutely no evidence to support his allegations, and the trial court was correct in denying the motion to dismiss and the request for a Travers hearing based on the fact that he submitted no evidence.
Isn't his affidavit evidence?
It does, but he didn't submit any supporting evidence to support the statements he made.
And are there any first department cases that says that an affidavit has to be supported by supporting documents in order to merit a Travers hearing?
We do have a second department case, TBF.
I was asked you about the first department.
I'm sure I could find some, but not in.
Thanks.
It wasn't cited in here. And if I may address the statute of limitations argument.
No, but thank you.
Okay, thank you.
Ortiz versus New York City Department of Motor Vehicles.
Good afternoon, Your Honors. May it please the Court, my name is Danielle Muscatello. I represent the petitioner in this matter, Mr. Edwin Ortiz. Not a great start. I want to focus on the second point of my brief, if I may, which is that the continuation of conducting these virtual hearings via teleconference, or where the administrative law judge forces the police officer to turn on his camera, it's in violation of law. It's in violation of due process. It's in violation of the State Administrative Procedure Act.
Why is it in violation, and where is it? What is your?
It violates constitutional due process under the federal constitution, under the state constitution. It violates the state.
Holding that?
No, there's not, and there needs to be.
So what's your basis for your statement that it's in violation of the Constitution and due process, et cetera?
Well, if you go to the decision by the appeals board, they stated, quote, "The hearing procedure represents a reasonable, targeted, and lawful balance between significant government interests involving public health and safety and the private rights and interests of the respondents." Right? Matthew versus Eldred, United States Supreme Court precedent. That is the due process balancing test that applies to administrative proceedings. So we start there. Then we have the VTL. We have 1194, which governs these chemical test refusal hearings. We have the State Administrative Procedure Act.
I'm sorry. Are you? Sure. You're speaking to the fact that this was a virtual hearing?
Yeah. Yes.
Okay.
Yes. Absolutely. There is no continued justification why the department and the commissioner continues to conduct proceedings in this way. I think importantly, I see Your Honor wants to say something, but in the Attorney General's—
You'll know when I want to say something.
Yeah, I've watched.
Trust me.
In the Attorney General's brief, they indicate that these thousands of these have been done and that there's been no objection. Well, we're objecting. The fact that it's been done before doesn't mean it's lawful. This was enacted.
Why exactly is it a violation of due process? The police officer turned on his camera.
Right.
Right. So his camera's on.
Right.
There is the examination, questioning, etc. So why is that different in a virtual form? Why is that different from a live proceeding, in-person proceeding?
Because it is.
I'll give you a little bit more than
Craig versus
why is it?
Craig versus Maryland. They talked about live testimony, live video.
This is
consultation.
live. This is live.
Right,
it's just that it's virtual. But the people are there. It's not taped. It's not a tape recording.
But in every case, at least in the criminal matter, in every case where I found precedent, People versus Rotten in the Court of Appeals, these other civil matters that the AG cites in their brief, there's an exceptional circumstance. There's a case-specific finding, whether you have an incarcerated individual, you have a vulnerable child, you have, the COVID-19 pandemic. So,
counsel, I have to tell you, we are moving to the point where we are having more and more virtual proceedings in the criminal context, also in the family court context, in the housing court context. In every proceeding in this state, we're moving towards virtual proceedings because we find that they can be more convenient. So again, I need to know exactly what is the difference between an in-person hearing and a virtual hearing, when you're talking about due process, when you're talking about the presence of the litigants, of the witnesses, the right to confront them, the right to question them, the right to see them, the right to assess their credibility. How is it different?
There's, anyone who has practiced knows that when you are face-to-face, and I know you're also experienced, when you are face-to-face, confronting a witness, the psychology of a face-to-face, the psychological element, if you will, sorry to be an artful, of a face-to-face confrontation, of using documents, of posing questions by surprise. There is a nuance, and the Court of Appeals said it in Matter versus Barrenhouse versus Ward. They spoke of the ability to perceive inflections, pauses, glances, gestures, nuances of speech and manner.
This is lacking in a virtual proceeding?
There can be delayed, there can be a delay in transmission, a breaking up of the proceeding. Yeah.
Let's cut right to the chase. How did the virtual proceeding impede Mr. Ortiz's ability to participate?
Well, I see my time is up, and
no, you can answer that.
Yeah, I mean, and I knew your honors were going to talk about the issue of substantial prejudice. My position, I'm going to answer your question,
No, now, please. Thank you.
that well, first of all, the officer didn't recognize him. He didn't even recognize him. They said, do you see him here? Do you see the motorist here? And the officer said no. The judge at the end, ALJ Torelli, said at the very end that he was really struggling. This was a gut credibility determination. We didn't have the opportunity to show the video live. We couldn't do that. The video substantially undermined this officer's testimony. We had an expert who was far more experienced than the arresting officer that the ALJ didn't get to speak to in person. There are nuances that are lost, and this is a substantial right. I just need to conclude with this. I know I have rebuttal. These are people's driver's licenses, substantial property interest, and to just move to virtual proceedings without any, by the way, the TVB, the Traffic Violation Bureau, they moved back. They did virtual proceedings for a little while, and they moved back to in-person proceedings where they're now giving motorists the option. Continue to give them the option for a criminal case and other family court proceedings and such that your honors reference. Sure, if I'm home and I have my toddler and I need to do a quick adjournment, sure, there are proceedings that can be done virtually for expedience, for convenience. But these virtues cannot be eroded so far when you're talking about a substantial property interest.
So the inability to offer the, you said a video?
So the video.
You were not able to offer this video, is that what you're saying?
It was emailed after the fact.
Okay, so was the inability to do so because it was virtual, or was the inability to do so because of something else? Meaning, if it had been a live proceeding, would you have been, are you saying that if it had been a live proceeding, you would have been able to offer this video, but because it was virtual, you could not?
No, actually, I can't, no. I'm not going to say that.
So again, what was it about the virtual proceeding that in any way impinged upon your client's rights? Because you mentioned also something about testimony of another witness. So was the failure to present that witness's testimony because it was a virtual proceeding?
No, the testimony was presented. My argument is that when you're litigating, when you're going to deprive someone of a substantial property interest.
I understand what your argument. I understand what your argument is, and we've all been litigators.
I know.
The question again is, what was it about this virtual proceeding that impinged upon your client's rights, in that what was it about the virtual proceeding that prevented him from putting on his case and for presenting a defense? Well, you can think about that and answer on rebuttal.
Good afternoon, Your Honors, and may it please the Court. Anaga Sundarajan for the Attorney General's Office on behalf of the respondents. I'd like to begin, Your Honors, with your last question. And the fact of the matter is, there is no argument in Ortiz's briefing that claims any kind of specific prejudice in this case as a result of the virtual.
The only possible argument that I see is perhaps the fact that it is not, that the parties are not required to consent. So in a lot of the proceedings that I was speaking about, family court proceedings, some criminal court proceedings, it allows the petitioner, respondent, et cetera, defendant to consent. There is no, that was not allowed here. This was over his objection, I believe.
That's correct, Your Honor. However, when we're looking at the due process balancing, the prejudice needs to be something more than that. And the Court of Appeals has acknowledged that the question for due process is whether all of the substantial elements of a fair trial are present, and they were here. Mr. Ortiz was entitled to cross-examine the officer. He could see the officer. He could hear the inflections in the voice. There's nothing in the record to suggest there was a delay or a lag or the video was problematic in any way. He was allowed to present his own witness. The witness was able to present testimony. Again, everyone was visible. Everyone could be heard. There's nothing to suggest that there was a delay. And again, Ortiz doesn't point to anything about what he would have done differently had this happened in person. In fact, my colleague on the other side noted the video. However, Ortiz never asked the officer to show the video. He never asked the ALJ to move the video into evidence or to play it for the ALJ. So that is simply insufficient to show prejudice.
And as Your Honor noted, these kinds of virtual hearings have increased in frequency, and they've been doing so not only across the state, but across the country. And every court that has considered it has held that there's no problem with it. In fact, just last week, the Second Department confirmed in a very similar chemical test refusal hearing case that this kind of virtual hearing presented no due process concern. If Your Honors have any further questions about the due process issue, I'm happy to address it. I'm also happy to address briefly if Your Honor has any questions about the substantial evidence piece.
No, thank you.
Thank you, Your Honors.
I anticipated in preparing that Your Honors would be acutely focused on the prejudice component of this. And I thought a lot about it. And I'm sticking to my guns in that, you know, where in criminal proceedings there are motive proceedings errors. There are certain right to counsel errors. There are certain errors that are fundamental. For years, the chemical test refusal hearings were conducted in person. The confrontation clause contemplates in-person, face-to-face confrontation.
You still haven't told us, or at least I haven't heard it, any way that any specific way that your client was prejudiced by this hearing being conducted virtually. I've been listening for that, and I haven't heard it yet. Could you
You said you've been
address
thinking
that?
about it, and you knew that we would be focused on
Right, so what is it?
Well, and so I think and it ties into the first point, and that would be that when these cases come up on, like the other point is substantial evidence, right? When you're being asked to, and the court has to be very deferential to the ALJs, right? It's almost I don't want to say it's a rubber stamp because it's an important judicial function, but when the question is substantial evidence, there is so much deference. So now what we're doing, it's sort of a whittling away. We're saying, okay, he made the credibility determination, and he made it virtually. And a credibility determination that's made virtually without face-to-face in person is not the same. It's not the same, and there's the prejudice. This was such a close credibility question here. You had an officer who lied on the same type of DWI arrest.
Would have lied in person as well as
He would have lied in
virtually.
person
That's what
also.
I don't understand. If the officer's going to lie, it doesn't matter whether he's virtual or whether he's in person.
what I'm
A
saying
lie
is-
is a lie.
what
Are
I'm
you
saying is
saying that
not-
it's harder to ascertain a lie over video?
Yes, absolutely.
Why? Tell us why.
Because there's body language that can't be seen. This officer was sitting in a car holding his cell phone. That is not the same than having your reports in front of you, having your documents in front of you. And I see, I see you're looking at me like with such skepticism. But when you're,
She always looks like
I can't, as a litigator, I can't be firm enough about it.
Counsel, you make interesting arguments, but there's nothing, in the record to support this. And again, we're focused on this particular case in terms of Mr. Ortiz.
Right.
And so, we've asked this question now at least 4 times. What was it about the virtual proceeding that in any way impinged upon his rights? And you're saying it's a close credibility call, and it may have been a close call in terms of credibility, but it would have been a close call whether they were in person or whether they were virtual. That's what I don't get.
But especially in light of all of what your client was able to offer, his own witness, the video after, questioning the officer by seeing the officer on camera.
So then by rejecting the argument, this court is saying that the DMV can continue taking away these people's rights.
No, we're not saying that. No,
We
no,
would
no.
never- we
We're
would
not
never-
saying that.
we would
No, we're
never-
asking you questions about
Right.
how was it unfair. I haven't heard anything that.
We would never say that. How could we countenance any administrative agency or any court taking away the rights of individuals? We would never say that. We're saying that we're asking you, where on this record does it show that there was any deprivation of rights or denial of due process to your client?
The video wasn't cut off. No complaints about I can't hear. I'm disconnected. I can't ask questions. Nada.
We're just asking you to articulate it so we could say, okay, we could see that where because of video, then this might necessarily be what happens. And so because of that, this might lead to prejudice.
Right.
Thank you both.
I was just going to say, I understand, and counsel did a really great job here of making the record. But when an administrative agency is violating the law, there shouldn't need to be a substantial prejudice. Had he not,
I think that was like the first question we asked 10 minutes ago was what law or what rule was violated by this virtual proceeding?
Section 501 of the Administrative Procedure Act and due process.
Says Section 5, really that section says that you cannot have virtual proceedings?
No, it says it affords a right to appear in person by or with counsel.
Go ahead.
I'm sorry.
How can the TVB justify now doing, eliminating the Traffic Violation Bureau? They've eliminated virtual proceedings for motorists with traffic tickets. Right now they have the option. They're back to in-person. They've been back since 2021.
So the next time your client gets a traffic ticket, he'll get an in-person hearing. Works, right? But thank you very much.
Thanks.
Thank you both.
Have a good afternoon.
You too. Take care. Interesting argument. Supply Company versus Hardy Way.
They submitted.
Oh, they submitted. Thank you so much. Huh? David Williams, right? Yeah. Yeah, thank you. People v. David Williams.
Good afternoon, Your Honors. Ariel Smallwood of the Legal Aid Society on behalf of Appellant David Williams.
So he's out, is that correct?
That's correct, Your Honor.
Because in your papers, you asked for a reduction of the sentence from 5 years to 3 years, but he's already, 4 years. You wanted a reduction of the 4-year sentence, but he's already done the sentence. So what you're actually asking for is a reduction of the post-release supervision, right?
Your Honor, he has served 3 years of the 4-year sentence. He's currently out on parole, and the post-release supervision period of 5 years is a mandatory period, so this court cannot reduce that period. We're not asking for a reduction of that period. We're asking for a reduction of the incarceratory period to recognize the fact that Mr. Williams has served 3 years of that sentence. That's a significant amount of time for him at age 47, and to reduce that by 1 year, which would have a significant impact on him.
That would terminate him from his parole obligations.
I'm sorry?
That would terminate him from his parole obligations.
It would terminate him from the incarceratory portion of his parole obligations, but there's still the mandatory 5 years.
Right. Yeah, but he would no longer be on parole, and he would just have the 5 years post-release supervision.
That's correct, Your Honor.
Okay.
A 1-year reduction is consistent with the principle of minimum confinement necessary based on Mr. Williams' acceptance of responsibility, the anomalous nature of this offense, the 3 years of prison that he's already served, his age, and his support.
So this is the attempted criminal possession of a weapon in the second degree.
That's correct.
So this is where I think there were Good Samaritans, for want of a better word. Is this the case with the Good Samaritans? They were helping the young lady that he was having an argument with?
Yes, this is the
And then he came back with a gun, and he said there's no video or something like that, so I can shoot you and nobody would know, something of that nature.
Your Honor, he did make that statement, which...
And he was found in possession of the weapon, is that correct?
He was, which he admitted to police the day that he was arrested.
And he has 6 prior felonies and 6 prior misdemeanor convictions?
That's correct, mostly drug offenses. Yes, Your Honor, this is his first violent felony offense. His past history is mostly drug offenses from the early 90s to the early 2000s. He actually went to rehab 2 different times to work on those substance abuse issues, and because of the past nature of those substance abuse issues and the anomalous nature of this offense, we're asking for a 1-year reduction. As to the acceptance of responsibility, as I stated, Mr. Williams gave a statement to the police admitting possession of the gun on the day that he was arrested. He pled within 6 months of his indictment, so there was no delay in terms of accepting that he did possess the gun. He has a very supportive family, and at the age of 47, he has a teenage daughter who requires his guidance, and at his age, he has certainly seen the error of his ways and the anomalous nature of this case, but also that the 3 years of prison that he served was a significant amount of time. It's his most significant incarceratory period, and he is, quite frankly, at the point where he has the will to change and the want to change. And to turn to the supervision, the post-release, the mandatory period of post-release.
You said he had a teenage daughter.
Yes, Your Honor.
Why did the pre-sentence report indicate that he had no children?
Your Honor, we're not sure. At the sentencing minutes, the defense counsel wanted to correct the probation report to reflect that he does have a teenage daughter. He tried to delay the sentencing in order to make sure that his teenage daughter had the appropriate care, but the court said that they would not correct the probation report because it was not under their control. So that's why there's the discrepancy between the probation report and the sentencing minutes.
Wasn't there also something about he lived with his mother?
I'm sorry, could you repeat that?
Wasn't there also something that he lived with his mother?
Yes, Your Honor. He lives currently with his mother and his stepfather, and he returned to their home after he was released, which gives him a supportive family situation and allows him to have this ability to easily find employment and to be able to be successful on post-release supervision. And turning to the post-release supervision, the less is more is implicated, and less is more indicates that longer periods of supervision are harmful and too much supervision is counterproductive. And so for Mr. Williams, who will have to discharge his parole obligations if this court reduces the sentence by 1 year, but still continue to have his post-release supervision that includes reporting, dealing with trying to make sure that his employment is compatible with being able to make the reporting obligations, childcare, transportation. And so that responsibility is onerous, and we're asking that this court reduce his sentence for his incarceration.
Childcare. He lives with his mother and his stepfather, you said. You didn't say he lived with the teenage daughter.
Well, Your Honor, he does still have shared custody of his teenage daughter, so there may be issues of childcare that come up with his reporting obligations. And I see my red light is on.
Yes, thank you. You have time on rebuttal.
Good afternoon, Your Honors. May it please the court, Jacob Marcus for the people. First, I would like to clear something up with regard to the allegedly anomalous nature of this offense. While most of defendant's prior convictions are drug-related offenses, in 2015, he was convicted upon his guilty plea of menacing in the second-degree sub-1, menacing with a weapon. That was indicated in the rap sheet, as well as, I believe, the pre-sentencing report, and was properly in front of the trial court. Additionally, at the time he was sentenced, he had an ongoing case, again, for criminal possession of a weapon and menacing to sub-1 with a weapon. While the people didn't move forward with that, that was properly in front of the trial court at the time the sentence was handed down. Now, defendant's sentence, which imposed 11 fewer years of imprisonment than he would have otherwise been subjected to, could have been subjected to, was neither unduly harsh nor severe. And
But he was a nonviolent is that correct? A nonviolent predicate felon, is that correct?
Yes, Your Honor. He was a second-time predicate felon, with the present offense being a violent felony offense, the prior ones being nonviolent, which means under the originally charged Class C felony, criminal possession of a weapon in the second degree, there would have been a statutory minimum of 5 years determinate sentence, 15 years maximum. So that entire spectrum of legal sentences was greater than what he ended up receiving. Instead, by permitting defendant to plead to attempted criminal possession in the second degree, he was looking at a statutory spectrum of 3 years minimum to 7 years maximum, and the court properly sentenced him to 4 years imprisonment, which was only 1 over the minimum, in addition to the statutorily required 5 years PRS. The sentencing court, in deciding to impose that lenient sentence, did so after reviewing all of the same facts that defendant now raises on appeal. And given that he was a predicate offender looking at 15 years in prison and ended up walking away with only 4, the sentence was lenient. It was not unduly harsh or severe and should not be disturbed upon appeal. If Your Honors have no further questions, we rest on our briefs.
Thank you.
Thank you.
To address two of the people's points, as the prosecutor pointed out, they did not move forward, could not move forward with that second menacing case. So the people did not have the evidence to for that case, and so therefore should not be considered. And as to his second felony offender status, the 3-year minimum already considers that he is a second felony offender with this offense. And Your Honor, I will rest unless Your Honors have any further questions.
Yep. Thank you.
Oh,
Thank you
thank
both. Mirin versus Memorial Hospital.
Your Honor, we're not supposed to use our phones, so I don't know whether to say good afternoon or good evening right now. I think we're close to 5.
We're almost at 5.
All right.
Good afternoon.
Good afternoon, Your Honors. Payne Tadge from Chabani, Citron Spratt, attorneys for the defendant appellants. The Supreme Court incorrectly denied a defendant's motion seeking only a hearing to determine whether or not a guardian ad litem should be appointed for plaintiff in this case. We did not seek an appointment as a matter of law in the papers. Rather, we only sought for a hearing to be conducted so that the court could examine and determine whether or not...
Is there even a high burden in order to, for the court to order a hearing on this issue?
No, the burden on the hearing is whether or not there's a question of fact as to whether someone should be, or whether a guardian ad litem should be appointed. The burden at the actual hearing is the preponderance of an evidence finding that they must be
Okay, so what did you present to show that you, defendant, to show that the plaintiff, that there should be a guardian appointed?
Yes, Your Honor. There were 3 general categories of evidence. The first one being her treating physician's records, and there's multiple ones, but primarily Dr. Dunkel, her neuropsychologist, and that was before she brought the claim. The second was plaintiff's own testimony and statements she made therein. And the third one was a letter from the Social Security Disability Board who had issued her a letter saying that she needed a representative to collect payments because she couldn't manage her own.
Standard from whether or not she needs an Article 12 guardian, correct?
I'm sorry?
The Social Security determination is not identical to the issue that has to be resolved for an Article 12 guardian, correct?
No, they're not. It's just some evidence towards that question of fact, and it's one of many things that we pointed out.
Okay, so let's look at her deposition testament. First of all, her deposition was 11 hours.
That's correct, and it was over the course of 3 days.
But it was still 11 hours over the course of 3 days, which would be taxing for any person. And there was nothing in the deposition testimony that showed that she had any issues, did not understand the questions, or again, required a Article 12 guardian.
Well, I don't know that I would necessarily agree with that. I would say first, the idea that we're looking at the depositions and the IMEs isn't necessarily the same standard under CPLR 1201.
Okay, we're looking at the depositions. We're looking to the IMEs, which you mentioned. She submitted to 4 IMEs.
That's correct.
And she also appeared at the site inspection, right?
That's
so
correct.
Again, we have all we have this the deposition, site inspection, 4 IMEs, all attesting to the fact that she understood what was going on and did not need a guardian.
That's correct. Now, I do think...
And I think your own experts, didn't your experts also say that she did not, that she understood what was going on?
Well, I would say that they agreed with that to some degree, but then there were some things that they would actually dispute that. Going back first to what you said about the deposition,
What things would they dispute that on? And where in the record is that?
So she had said that they said that everything was going on.
No, your experts said that there was no valid or reliable evidence of cognitive defect due to the accident. That's what your expert opined.
Yes, he also said that she exhibited some memory and attention test scores that were characterized by those persons who are in a prolonged coma or had extensive structural brain damage. That's record 701.
Due to the accident?
No, but see, this is actually kind of the point that they've tried to walk us into this trap. That there's significant psychological and emotional things that occurred before the accident that are unrelated to the actual accident. And as a result...
Counsel, I want to get straight to the chase.
Yes.
So what facts did your client present to show, the plaintiff, she doesn't understand the proceedings, she can't defend, her rights, she can't assist counsel. Let's talk about those three things.
Yes.
What did you lay out to show those three
Yes,
things?
of course.
Because if you didn't show that, then we know where we're going here.
That's correct. I'll go back to the three categories I talked about before.
The categories that I'm discussing, that's what I want you to focus on.
Yes, it's the same answer. The three things that we pointed out. So the deposition, she testified at record 256, 257, I don't understand the question. 255, the question's too long, I can't understand you. 559, she actually ties together at 559. She says, throughout this deposition, I asked you to repeat several times the questions. And she says
And I think we can all agree that we have never seen such responses in deposition testimony, where the deposed party states, I don't understand your question, or please repeat your question. I've never seen that in a deposition.
You're correct.
Rebuttal, you have rebuttal. Thank you.
I think I can officially be the one. Good evening, Your Honor.
Now your evening.
May it please the court, Leonard Weiner from Myers-Swazi English and Klein for the plaintiff respondent, Dr. Svetlana Mirinov. The lower court was correct in its two findings in denying this motion. The appellant first failed to present evidence tending to show my client doesn't understand the proceeding, that she can't prosecute her rights, and that she isn't assisting counsel. And when there's no question of fact, there's no hearing. And that's exactly what the Supreme Court ruled. Second, and the appellants haven't disputed this in their briefs, they haven't disputed it today, is the lower court's reliance on this court's decision, Nova, from 2007. The rationale for the appellant's request to protect their own rights, their carrier's rights, their client's rights, their attorney's rights, is contrary to the rationale for the appointment of a guardian ad litem under Article 12.
Did they ever express at any point any concern about protecting her rights?
No. They're only concerned if we potentially have a settlement, that somehow she can disrupt the settlement in the
I just
future.
wanted to make sure I hadn't missed that in the record.
No, that is it. And if there are no questions, I will rest on the briefs.
Thank you.
Going back to the question about what evidence there is that she has difficulties prosecuting her rights. Currently, she's gone to deposition. She's gone to IME. She answers questions about the past. In the future, she's going to have to go to trial. She's going to have to weigh considerations as to whether she should accept a potential settlement offer, weigh them against deposition or trial testimony that's come out that may cut against that. She's going to have to read a settlement agreement or at least have it explained to her and then contemplate whether she should accept that.
It could be true for anyone that by the time it gets to trial, they would not be as competent as they were now. But
well, that's true. But
still has to be some showing before you can, before you can go.
I'm sorry.
Starting to go down the road of minimizing someone's rights, and I don't see where you've shown that.
Her treating neuropsychologist before she filed this action stated that she needs assistance with complex decision-making. He described how when she becomes easily angered and frustrated, she gets overwhelmed.
And
Her
that was
autonomic...
6 years before this motion was decided.
Yes, that was before. But he's made several statements, which in his affidavit, he didn't retract, he didn't explain. He filled out a one-page affidavit.
In his current affidavit, he said she's capable of prosecuting or defending her rights in this matter, right?
He says that. It's a little suspicious that he would know what she can do to defend her rights, given that he's not legally trained. But also, that affidavit is one page, double-spaced, compared to 16 pages, single-spaced of an evaluation that he made. He doesn't go into detail.
That evaluation dated from when?
That's 2016, but there are more.
A long time ago, counsel, isn't it?
When she testified in 2021, she explained that she can't remember her grandchildren's names. She loses 4 to 5 cups of coffee a day. She fears that when she almost flooded her apartment, she stated, because she filled the bathtub and forgot that it was running. She can't read books because she states the comprehension is not there. She can't watch movies with long conversations, which is also why at her deposition she said that the long question, I can't understand. So there is evidence here, and all we're looking for is an issue of fact that would give the hearing, which is, if I may, I know that the red light's on, just address very quickly.
No, but thank you.
Thank you, Your Honor.
Last case for argument, Lindaman versus VNO 100 West.
Good evening, Your Honors.
Good evening. You may proceed.
Thank you. I will like to briefly address first the negligence in 200 claim. Respectfully, the lower court erred by dismissing that claim. In its decision, it first of all misstated the law. It said that the claim should be dismissed because it was an open and obvious condition.
What your client testified to. What your client said it was open and obvious.
Yeah. Well, it was an open area. He didn't know it would cause.
He said it was obvious to him. I mean, obviously he didn't use the legal term open and obvious, but he said it was obvious to him. He was able to see that the computer floor was raised and unfinished.
Correct, but first of all, he did not know.
He admitted that he knew he had to step over pedestals to get onto the raised floor. He had seen the pedestals as he approached the floor prior to his accident.
Absolutely.
He knew the pedestals were there and that he had to step over them.
Absolutely, but that not in and of itself is a basis to dismiss a claim. At most, that would go to comparative negligence, and he was directed to work in that area, and there was no protection. In this court's recent decision in the Spencer case, this court specifically said, in that case, the plaintiff was well aware of the debris that was in the area and that was created by his own employer, and at most, that would go to comparative negligence. That is not certainly a basis to dismiss a claim. And secondly, that gets tied in with the fact that the lower court said that how can this be a dangerous condition when plaintiff's employer was the one that was installing the raised computer floor? Obviously, the raised computer floor was not installed by plaintiff's employer. They were the sheetrock carpenter.
So for your 200, you have to show that there was an inherent defect. Defect was inherent in the property, right?
Absolutely.
So how did you show that?
That, first of all, we have an expert who said it was a defect. Their expert, Mr. Moore, said it's not a defect. But what is telling is the ultimate expert here, Mr. Robert Crossan from High Tech. He was the president of the company, the raised computer company that installed the floor. And he even, on page 742 of the record, acknowledged that that could be a tripping hazard, a potential tripping hazard, and he was an adverse party.
Are you referring to his incomplete sentence about whether or not somebody could?
But it was not an incomplete sentence. He acknowledged that it was something that could be a potential tripping hazard. Here you had an uncompleted floor. There was no protection. My client was the sheetrock worker, the carpentry worker. He had nothing to do with that. There was an obvious gap right at the edge, and that would be something that would be, that they were certainly on notice. Mr. Forster of the GC admitted that he inspected, although he apparently inspected the wrong area, but 10 times before that, not to mention that they acknowledged that they were responsible for site safety. They didn't even hire a site safety contractor. They, Icon, were responsible for site safety. And he admitted that, yeah, I inspected the area 10 times for tripping hazards. And he said, he was asked, well, when was the last time you inspected the area before the accident? He says, I don't know. of the case law, including the Spencer case and multiple cases, they didn't even establish that their proof, putting aside that at barest minimum, there's a question of fact whether ICON, which was responsible for site safety, they inspected the area 10 times. They weren't doing it for a social visit. He was the guy. And he admitted that he doesn't even know when he last inspected the area. And he was talking about another area. Well, those areas would not have pedestals like the ones that plaintiff tripped on, and that was even the wrong area, but certainly it shows he acknowledges that that would be a potential tripping hazard. He's responsible.
You have time on rebuttal.
Thank you.
May it please the court, Frank Wennick from Amity Demers and McManus for respondent. If I could just talk about open and obvious for a moment. Open and obvious and inherently dangerous is the test. And so open and obvious, I agree, is a comparative negligence issue that comes before the court. But when the alleged defect is also inherently not dangerous, then that can be something as a matter of law that this court can rule is safe.
And isn't it also significant that the pedestals were integral to the work still being performed?
Yeah, absolutely. They were in the middle of putting this together, and in fact, he got his cord hung up somehow on what this was. So he was in the middle of this progress of the construction. So it was inherent in the construction that he'd be moving from one plywood board to the next plywood board, and he somehow got his cord caught in this, and he had to step up to get it. So yes, absolutely, it's inherent in the work. Okay. The other thing about inspecting 10 times a day and not seeing something is because it wasn't dangerous. Because as the court pointed out earlier, that the plaintiff admits he could see what it was, that it was open and obvious, and it wasn't inherently dangerous. And therefore, there was nothing for him to see, not that he missed an alleged dangerous condition. I'd like to talk for a minute, if I could, about 241-6. I would note that in the appellant brief, he didn't cite any cases regarding the height that might be necessary to require vertical passage. And then we pointed out in our brief that he hadn't done that, and so he came back in the reply brief and he cited a bunch of cases, and I just thought I'd take the opportunity to talk about that for a minute. So in LELEK, L-E-L-E-K, it was a 2.5 to 3 foot difference that was ruled to require vertical passage. In Ferguson, he was directed by his employer not to use the stairway, but to instead use an inverted bucket. Again, I think highly distinguishable. Dotto, D-O-T-O, the 241-6 claim was dismissed in that case. So I don't think that can be precedent for him. And in Davis, no height was mentioned. So I think under 246, you've got Torkel, which ruled exactly on the 18 inches that did not require vertical passage. And also Francescon, F-R-A-N-C-E-S-C-O-N, versus Gucci. This court held 12 to 15 inches is not enough. And their expert didn't refer to any industrial code, referred only to guidelines. So the plaintiff's brief admits, the plaintiff expert admits that they do not have any specific code to rely on for that. So I think the 241-6 claim absolutely should be dismissed. And also about the general contractor, when they're responsible for general oversight as opposed to the supervision of the work, that is when they can have the case dismissed as to them. And there is absolutely no contention whatsoever that ICON supervised the plaintiff's work. He testified that he got his work only from his foreman, and that's the only place he got it. And so even there, you can't have responsibility for the general contractor. If the court has any more questions, I'd be happy to answer.
No, thank you.
Thank you.
Supervision and control of plaintiff's work has an
Well, counsel, you want to address the 241-6?
Absolutely. With respect to the 241-6, first of all, I agree with Justice Gessmer about integral to the work, but that applies to 1.7E. This is not a tripping hazard 1.7E claim. This is a vertical passage claim. And my
Well,
expert...
that's the issue. How does it become a vertical passage?
It becomes a vertical passage, and first of all, the cases that counsel cites to, one of them was a bunched up carpet. Here we have an uncompleted floor that led to where you go right from one level to an uncompleted level where there was a protruding metal, and there's a question whether it was 18 inches or 8 to 10 inches, but that's an uncompleted floor. And my expert said that, and he did cite to 1.7F, that a ramp would be something that would have prevented an accident like this, given that you have an uncompleted floor. And my client, again, was not the contractor that built this floor, and that's what the lower court hinged a lot on, and that's a mistake of the record and a mistake of the law. The fact of the matter is my client worked for a general contractor, his company, and they were responsible. It had nothing to do with supervising plaintiff's work. They were the only safety company around. And he admitted, I inspected that area. Again, he hinged it on a different area where he said, well, the pedestals in that area were not sticking out. In the area where he did not inspect, the pedestal was obviously sticking out because there was no covering. It was right next to the concrete floor. And then when my client, who was doing sheetrocking work, stepped, regardless if it's an open and obvious condition, he was caused to trip, and there was no proper protection. Certainly, they violated Labor Law 200 at the very least. Based on the record, there's a question of fact for a jury to determine, and we have a battle of the experts.
Thank you very much.
Thank
Thank
you.
you. Have a great evening.
Welcome aboard, Your Honor.
Yes, welcome.